Would you like to make £150,000 a year in your first job? Newly qualified solicitors actually get this amount of money. But if you're a law student, you probably already know that to get there, you need to go through the SQE. There are 4 key chunks of knowledge that you need to conquer in order to pass this exam. I'm Dr. Yannis and I've been teaching undergraduate students just like you for the last 20 years. In this video, we're gonna start with what you need for wealth management: property law, land law, wills and estates, trusts, and leases. I am now going to pass you on to my team. They will explain everything with a great set of slides.
Picture this: you're house hunting, scrolling listings, and you see a cottage that looks almost too good to be true. Same street, same size, but for some reason it's miles cheaper than everything else. You ask the agent what the catch is, and they give you the line in that polite, careful voice: it's being sold subject to the occupier's rights. And then you meet him. An elderly man, living there, calm as you like, not moving, not temporarily staying, properly in occupation. The paperwork makes it clear he has the right to remain. The price suddenly makes sense. You haven't bought a cozy cottage with vacant possession. You've bought a cottage with a human timetable attached to it. But in your head, you do what people do. You start quietly running the numbers. You tell yourself, not out loud of course, that this is a bargain because he can't live forever. You think you've found the loophole listing, a property investment with a built-in just wait strategy. So you buy. And then time passes, and he's still there. A year goes by, then another. He's still there, still pottering about, still watching Netflix, still very much not cooperating with your unspoken business model. Eventually, you decide you want your house now. You convince yourself that whatever his arrangement is, it can't be that strong. Surely it's just a bit of informality. Maybe he's basically there by permission. Maybe you can push him out. That is the moment landlord turns from interesting academic detail into a judicial slap in the face. Because in Binions v. Evans, that is essentially what happened. Buyers purchased land at a reduced price because an elderly widow was in occupation and was meant to be able to stay. The purchasers then tried to treat her as removable once they had the legal title, and the Court of Appeal said, in effect, you don't get to take the discount that reflects her right to remain and then try to pretend that right isn't real. Equity will not let you play that game. That is your first lesson in land law for the SQE. This subject is not just about who has the deeds or whose name is on the register. It's about how rights in land are created, what makes them legal or equitable, how they bind third parties, and how the law stops people using technical ownership to behave unconscionably. And yes, sometimes it's about the uncomfortable truth that people try to build property strategies around waiting for someone to die, only to discover that land law has a long memory and equity has even longer patience. How to think like a solicitor. This lecture takes you through the SRA FLK 2 land law specification in full. The aim is not just to recite rules, but to help you spot the issues, apply the correct framework, and explain the result clearly the way a newly qualified solicitor would in practice. Throughout, keep one practical mindset. Land law is about priority. When multiple people claim rights over the same piece of land, who wins and why? Almost every problem question reduces to 3 disciplined steps. First, identify the right that is being claimed. Second, classify it as legal or equitable. Third, work out whether it binds the relevant person, usually a purchaser, lender, or successor in title, by applying the relevant protection and priority rules. Land problems also carry professional obligations. In practice, you must act honestly, with integrity, and in the best interests of each client, while still complying with duties to the court and the wider public interest. The SRA principles set out those baseline duties, including rule of law, public trust, independence, honesty, integrity, equality and inclusion, and acting in each client's best interests. The SRA's competence statement frames those ethical and professional behaviors as part of being competent, not optional extras. In SQE terms, that means you should be alive to conflicts of interest, undertakings, misleading the other side in sharp practicing completion, and fairness in advising vulnerable clients. Now we move item by item through the specification. Distinction between real property and personal property. Real property is land and interests in land. It is real in the historical sense. It was recoverable by real actions, and it attracts a specialized system of estates, registration, and third-party priority. Personal property is everything else. It includes chattels, money, shares, intellectual property, and shows in action like debts. Personal property generally transfers by delivery, assignment, or contractual mechanisms. It does not carry the same registration-based priority structure as land. Why does the distinction matter for SQE questions? Because remedies, formalities, and enforcement differ. A dispute about a car is a dispute about personal property. A dispute about a right-of-way, a lease, or a beneficial interest in a home is land law. And the analysis is built around estates, interests, and whether the right binds third parties. How to acquire and transfer legal estates. In modern English land law, the menu of legal estates is deliberately narrow. The Law of Property 1925 reduces legal estates essentially to the fee simple absolute in possession and the term of years absolute. In plain English, that is freehold and leasehold. A legal estate is acquired either by original grant from the Crown in the distant past, which is not how we think about it today, or far more commonly by transfer from an existing owner. In registered land, a transfer of a registered freehold or registered lease is not complete at law until registration. This is one of the defining ideas of the Land Registration Act 2002. Title is conferred by registration, not merely evidenced by it. In practice, that means the signed transfer deed is essential, but the legal title moment comes when the land registry updates the register. In unregistered land, the legal estate can pass on completion of a valid deed of conveyance, assuming the correct formalities are met. But in modern practice, many dealings trigger compulsory first registration, so the unregistered system is shrinking, even though it remains examinable. Always connect this to the client-based scenario. If your client is buying a house and you are told it is registered land, you immediately think contract, transfer deed, completion, and registration. If you are told the title is unregistered, you think deducing title from deeds, investigating pre-root title, and the land charges system.
How to acquire and dispose of legal and equitable interests in land. Land law distinguishes between estates and interests. An estate is a time-limited slice of ownership, such as freehold or leasehold. An interest is a right affecting land, often held by someone other than the estate owner. Interests include easements, restrictive covenants, mortgages, and beneficial interests under a trust. Then you distinguish legal and equitable. Legal rights tend to be stronger and, crucially, are capable of binding the world without needing notice in the ordinary sense, because the law gives them proprietary force. Equitable rights are also proprietary in nature, but their enforceability against third parties is controlled by equitable doctrines and, in modern systems, by registration, overreaching, and priority rules. A legal interest is typically created by deed, and if it is registrable in registered land, it must also be completed by registration to take effect at law. An equitable interest can arise from a written disposition that does not meet the legal formalities, from a trust, from proprietary estoppel, or from other equitable doctrines. Disposal is the flip side. Many equitable interests must be disposed of in writing. Some equitable interests are overreachable, meaning they can be swept off the land and attached instead to the sale proceeds, so that the buyer takes the land free of them, provided the correct statutory conditions are met. In exam terms, when you see beneficial interest plus sale by trustees, you should hear the word overreaching in your mind.
Methods to protect and enforce third-party interests. Third-party interests are the heart of land law problems. A third-party interest is any right held by someone other than the person appearing to own the land, usually the registered proprietor or the legal owner in an unregistered title. Protection depends on whether the land is registered or unregistered. In registered land, the main tools are entry on the register by notice, entry by restriction, and the special category of overriding interests that can bind even though they are not entered. The priority rules in the Land Registration Act 2002 then decide whether the interest binds a purchaser or a lender. In unregistered land, protection is achieved through the Land Charges Act 1972 registration system for certain interests and through the doctrine of notice for other equitable interests. Enforcement means asking, can the holder of the interest assert it against the current holder of the estate? If yes, they can usually seek injunctions, damages, specific performance, or proprietary remedies depending on the interest. If no, the interest may still be enforceable personally against the original party, but not against successors. As a solicitor, you also enforce by good process. You carry out searches, inspect the property, ask the right inquiries, and advise on risks. That practical dimension is often what the SQE problem question is testing. Different ways in which land can be held. Held here means both the estate structure and the ownership structure. At the estate level, land is held either freehold or leasehold. A freehold is potentially indefinite in duration, a lease is time-limited, even if it is very long. At the ownership structure level, land can be held by a sole owner or by co-owners. Co-ownership operates through the Trust of Land framework. The legal title is held by trustees, and the beneficial interests are held in equity by the beneficiaries. Land can also be held subject to burdens and benefits. An owner may hold land that is benefited by an easement, such as a right-of-way, and burdened by a restrictive covenant, such as a ban on running a business from home. For SQE purposes, always treat ownership as a bundle of rights and liabilities rather than a single absolute concept.
Legal formalities required to create and transfer interests and estates in land. Formalities are not decorative. They decide whether a right exists at law, exists only in equity, or does not exist at all. Contracts for the sale or other disposition of an interest in land generally must comply with Section 2 of the Law of Property Miscellaneous Provisions Act 1989. That means the contract must be in writing, incorporate all the express terms, and be signed by or on behalf of each party. If Section 2 is not satisfied, the contract is generally unenforceable. A conveyance of a legal estate or a legal interest is generally done by deed. A deed must be in writing, make clear it is intended to be a deed, be validly executed, and be delivered as a deed. Dispositions of existing equitable interests are controlled by Section 53 of the Law of Property Act 1925. In particular, a disposition of an existing equitable interest must be in writing, signed by the person disposing on it, unless an exception applies. Express trusts of land also require evidence in writing. Equity can soften harsh formality results through doctrines like proprietary estoppel and constructive trusts, but you must be precise. Equiting is not a general fairness override. It is a set of defined doctrines with defined elements. Registration of title to land. Registered land is now the default in England and Wales. The Land Registration Act 2002 governs the modern system, built around the register as the central source of title information. The register typically has three key sections. The property register describes the land and appurtenant rights. The proprietorship register shows who owns and the class of title. The charges register shows burdens such as mortgages and restrictive covenants. Three conceptual principles are often used to explain the system. The mirror principle is the aspiration that the register reflects the relevant rights. The curtain principle is the idea that certain equitable interests, especially beneficial interests under trusts, are kept off the register so buyers are not forced into family financial arrangements. The insurance principle is the state-backed indemnity scheme that compensates loss caused by certain registration mistakes. Those principles are ideals, not perfect truths, because overriding exists and because human behavior produces fraud and hidden realities. But they frame the reasoning. Estates that can be substantively registered. Substantive registration means the estate itself is registered, and the register is the source of legal title. In practice, the core substantively registrable estates you need for SQE are freehold estates and leasehold estates granted for more than 7 years. Legal mortgages over registered land are also protected and operate through registered charges. Compulsory first registration is triggered by certain dispositions, most notably transfers of a freehold, the grant of a lease for more than 7 years, and certain mortgages of unregistered land. The exam often signals this with words like "this is the first time the land has been registered" or "the title remains unregistered."
How to protect interests. In registered land, protection is mainly done by notices and restrictions. A notice on the register protects the priority of an interest, typically an equitable interest such as a restrictive covenant, an estate contract, or an equitable easement. If protected by notice, it will generally bind a purchaser. A restriction does not itself create priority in the same way, but it controls what can be registered. It is often used to protect beneficial interests under a trust by requiring, for example, that no disposition is registered unless there are at least 2 trustees, thereby facilitating overreaching. There are also situations where the law gives protection without entry through overriding interests. But overriding status is narrow and fact-sensitive. A prudent solicitor will generally aim to protect an interest on the register whenever possible, because relying on overriding status is risky. Interests that override registration and interests that need to be protected on the register. This is a high-yield SQE area. Overriding interests bind a purchaser even though they are not entered on the register, provided the statutory conditions are met. The Land Registration Act 2002 confines overriding interests largely to situations where it is unreasonable to expect entry on the register, or where the interest is obvious on inspection. The 3 overriding categories most commonly tested are short leases, interests of persons in actual occupation, and certain legal easements and profits. A legal lease for a term not exceeding 7 years can override. The practical message is that a buyer must ask who is in occupation and must read any tenancy arrangement, even if it is not on the register. An interest coupled with actual occupation can override. The classic example is a spouse with a beneficial interest under a trust who is in actual occupation. The leading authority is Williams and Glyn's Bank versus Boland, where the wife's beneficial interest coupled with her actual occupation could bind the bank. Purchasers and lenders respond with inspection and inquiries, and in practice with requiring overreaching by ensuring there are 2 trustees or a trust corporation to receive the purchase money. Actual occupation is fact-based and can include more than physical presence at the moment of completion. The courts look for a degree of permanence and continuity. Cases like Link Lending versus Bostard show that physical absence does not automatically defeat occupation if there is a continuing connection and an intention to return in appropriate circumstances. Legal easements can also override in some circumstances, especially those that are obvious on inspection or have been exercised within a relevant period, reflecting the policy that some rights are practically discoverable even if not entered. By contrast, many other interests need to be protected on the register by notice or restriction, otherwise they may be postponed to a purchaser for value. That includes restrictive covenants, estate contracts, equitable easements, and equitable mortgages. The examiner's common move is to give you an equitable interest, then tell you it was not protected, then introduce a purchase or mortgage and ask whether it binds.
Core principles of unregistered title to land. Unregistered title is deduced, not looked up. The owner proves title by producing a chain of deeds showing ownership, typically going back to a good root of title, traditionally at least 15 years, though practice and context matter. Because there is no single state-backed register of title, the legal system historically relied on documentary investigation and on rules controlling third-party rights, notably the doctrine of notice and the land charges registration system. In unregistered land, the key question is often whether the purchaser is a bona fide purchaser of a legal estate for value without notice. If they are, they take free of certain equitable interests unless those interests are registrable as land charges and have been properly registered. Role of title deeds.
Title deeds are evidence of title in the unregistered system. They show conveyances, mortgages, releases, and other dealings that reveal both ownership and burdens. A common exam twist is the buyer did not inspect the deeds carefully, or the solicitor failed to notice a restrictive covenant. In practice, professional negligence risk is high here, which is why registration has been so strongly promoted. Once land becomes registered, title deeds cease to be the primary proof of title, though historic deeds may still be relevant for interpretation or for rights not fully reflected on the register. Land charges. The Land Charges Act 1972 creates a registration system for certain interests affecting unregistered land, registered against the name of the estate owner. This is counterintuitive, so slow down. In unregistered land, some equitable rights are not protected by being in the deeds chain in a way that binds purchasers automatically. Instead, Parliament created registrable classes of land charges. If the charge is registrable and not registered, it can be void against a purchaser of the relevant kind, even if the purchaser actually knew about it. That is the crucial point. For registrable land charges, registration replaces the old notice analysis. Commonly examined land charges include estate contracts, restrictive covenants, and puisne mortgages. If you are told an equitable interest exists over unregistered land, always ask, is it registrable as a land charge, and was it registered correctly against the correct name? Name errors can be fatal. Continuing role of doctrine of notice. The classic equitable rule is that equitable interests bind everyone except the bona fide purchaser of a legal estate for value without notice. Notice can be actual, constructive, or imputed. Actual notice is what the purchaser knows in reality. Constructive notice is what the purchaser would have discovered had they made the inspections and inquiries that a reasonable purchaser would make. Imputed notice is knowledge attributed to the purchaser because their agent, typically their solicitor, knew it. In exam terms, notice analysis often hinges on whether occupation was obvious, whether inquiries were made, and what the solicitor should have discovered.
Differences between joint tenants and tenants in common in law and in equity. Co-ownership is a staple of FLK2. Begin with the structural point. At law, co-owners hold as joint tenants only. The legal estate cannot be held as tenants in common. Equity, however, can recognize either joint tenancy or tenancy in common in the beneficial interest. Joint tenancy means each co-owner is treated as owning the whole together, not a distinct share. Tenancy in common means each co-owner has a distinct undivided share, such as 50% each or 70-30, even though the land is not physically divided. The four unities underpin joint tenancy: unity of possession, interest, title, and time. Tenancy in common requires unity of possession, but not necessarily the other three. Practically, many disputes arise because couples assume we own it together, but that phrase could point to either equitable joint tenancy or equitable tenancy in common, depending on intention and evidence. Rule of survivorship. The right of survivorship, or jus accrescendi, applies to joint tenancies. When one joint tenant dies, their interest vanishes and the survivors automatically own the whole, without the property passing under a will. This can produce outcomes that match some people's expectations in family homes, but it can also produce outcomes people dislike, for example in second marriages, where someone wants their share to pass to children from a first marriage. Tenants in common do not have survivorship. Their share passes under their will or intestacy. In exam problems, survivorship often appears after a death. The key question becomes, was the joint tenancy severed before death? If yes, survivorship does not apply. Severance of joint tenancies. Severance is the process by which an equitable joint tenancy is converted into an equitable tenancy in common, removing survivorship. Severance can be done unilaterally by notice in writing under Section 36(2) of the Law of Property Act 1925. The notice must show an immediate intention to sever, not merely a future possibility.
Service rules matter, and cases show that even where the recipient does not read the notice, effective service can still sever. Severance can also occur by mutual agreement or by a course of dealing showing that the parties treated their interests as separate shares, such as negotiating a split or acting in a way consistent with separate ownership. In exam terms, the easiest marks come from stating clearly what severance does and then applying the method to the facts. If the facts show a written notice served, you focus on statutory notice. If the facts show negotiations and treated shares as separate, you focus on agreement or course of dealing.
Solving disagreements between co-owners by reference to Sections 14 and 15 of Trusts of Land and Appointment of Trustees Act 1996. Tolata is the statute that modernizes co-ownership disputes. When co-owners disagree, for example, one wants to sell and the other wants to stay, the route is an application to court under Section 14 for an order relating to the exercise by the trustees of their functions, including an order for sale or an order regulating occupation. Section 15 tells the court what to consider. The court weighs the intentions of the persons who created the trust, the purposes for which the property is held, the welfare of any minor occupying or expected to occupy, and the interests of any secured creditor. This is a balancing exercise, not a mechanical test. If the home was bought as a family home for children, the purpose may support postponing sale while children are minors, though not indefinitely. If there is a secured creditor, especially a bank, the creditor's interest is powerful. Many exam answers gain marks by explicitly walking through each Section 15 factor in a calm, structured way. The wider co-ownership framework also involves determining what shares exist in equity, especially where legal title and beneficial ownership diverge. The modern approach in domestic contexts is strongly influenced by cases such as Stack v. Dowden and Jones v. Kernet, which emphasize looking at the parties' whole course of conduct to infer or impute intention as to shares, while starting with the presumption that equity follows the law where property is in joint names. Essential characteristics of easements. An easement is a proprietary right enjoyed by one piece of land over another. It benefits a dominant tenement and burdens a servient tenement. The classic statement of essential characteristics comes from re Ellenborough Park. There must be a dominant and a servient tenement. The easement must accommodate the dominant tenement, meaning it makes the dominant land more useful or enjoyable. The dominant and servient tenements must be owned or occupied by different persons at the time of creation. The right must be capable of forming the subject matter of a grant, meaning it is sufficiently definite, not too vague, and does not amount to giving the dominant owner exclusive possession of the servient land. Examples include rights of way, rights to light, rights to lay pipes, and rights of support. Whether a claimed right is an easement often turns on whether it is too extensive, too vague, or inconsistent with servient ownership. Methods for creation of easements. Easements can be created expressly or impliedly, and they can be legal or equitable. An express legal easement is usually created by deed. In registered land, it may also need registration to take effect at law, depending on the disposition rules. Implied easements arise through several doctrines. Easements of necessity are implied where without them the land cannot be used at all, such as a landlocked plot requiring access. Easements may be implied by common intention, where the parties clearly intended the land to be used in a particular way that requires the easement, such as a commercial lease requiring ventilation equipment. Wheeldon by boroughs implies certain quasi-easements on a sale, where the right was used by the owner over one part of the land for the benefit of another part, and on division it is continuous and apparent and necessary for the reasonable enjoyment of the part sold. Section 62 of the Law of Property Act 1925 can convert certain permissions, privileges or licenses into legal easements on conveyance, sometimes unexpectedly, which is why conveyancers draft carefully to exclude its effect when needed. Prescription is another route, where long use as of right over time can mature into an easement, subject to complex rules.
For SQE, you usually need to recognize the concept and the requirement of long use without force, without secrecy, and without permission. Rules for the passing of the benefit and burden of freehold covenants. Freehold covenants regulate land use between neighbours. They can be positive, requiring action, or restrictive, prohibiting action. The benefit of a covenant can pass to successors if certain conditions are met. Statutory mechanisms, particularly Section 78 of the Law of Property Act 1925, can operate to annex the benefit to the land so it passes automatically, provided the covenant touches and concerns the land and the parties intended it to run. The burden is harder. The common law rule, illustrated by cases such as Osterbury v. Oldham, is that the burden of a covenant does not run with freehold land. That rule is reaffirmed in Roan v. Stevens. Equity, however, allows the burden of restrictive covenants to run under the doctrine from Tulk v. Moxey. The conditions are that the covenant must be negative in substance, it must benefit the covenantee's land, and the successor to the burdened land must take with notice of the covenant. In registered land, notice is typically satisfied and formalized by entry on the charges register. In unregistered land, protection historically depended on notice and, for registrable covenants, on land charges registration. Positive covenants generally do not bind successors directly, but there are indirect techniques, such as chains of indemnity covenants or the doctrine of mutual benefit and burden, sometimes associated with Halsall v. Brazell, where a person cannot take a benefit under a deed while rejecting a corresponding burden, though this doctrine is narrow and fact-specific. For modification and discharge, Section 84 of the Law of Property Act 1925 allows the upper tribunal to discharge or modify restrictive covenants in certain circumstances, such as where the covenant is obsolete or impedes reasonable use without substantial benefit. Modern cases like Alexander Devine Children's Cancer Trust v. Housing Solutions show the court's concern with deliberate breach and proportionality. Mortgages, including enforceability of terms, priority of mortgages, lenders' powers and duties and protections. A mortgage is a security interest over land to secure repayment of a debt. In modern registered land, a legal mortgage is typically created by a charge rather than by transferring the title. Creation depends on formalities. A legal mortgage requires a deed and, in registered land, registration of the charge. If the formalities are not fully satisfied, the mortgage may exist only in equity, which then raises priority issues. Enforceability of terms is shaped by the equitable protection of the mortgagor's right to redeem. The mortgagor's equity of redemption means that once the debt is repaid, the mortgagor must be able to recover the property free of the mortgage. Clauses that prevent redemption, postpone it unreasonably, or impose oppressive conditions can be struck down as clogs on the equity of redemption. Authorities like Fairclough v. Swan Brewery illustrate the court's hostility to provisions that effectively make redemption illusory. Priority in registered land is heavily governed by the Land Registration Act 2002. The basic rule is that interests rank in the order they are protected and completed, and a registrable disposition for value generally takes subject only to interests that are protected on the register or overriding. A registered charge will usually have strong priority because it is visible and formally protected. Competing charges typically rank by the order of registration, though there are rules about postponement agreements and, in some contexts, tacking and further advances. Lenders' powers include the power of sale, the right to possession, foreclosure, and appointment of a receiver. The power of sale is rooted in the Law of Property Act 1925, notably Sections 101 and 103. Section 101 confers the power when the mortgage is made by deed, and Section 103 sets conditions for when it becomes exercisable, such as default continuing for a specified period. In practice, mortgage deeds often contractually extend or vary these powers, but statutory foundations are a common exam focus. When exercising the power of sale, the mortgagee owes duties. A central case is Cuckmere Brick v. Mutual Finance, which establishes that the mortgagee must act in good faith and take reasonable care to obtain the true market value at the time of sale. The mortgagee is not a trustee for the mortgagor, but cannot sacrifice the mortgagor's interests by selling at an undervalue through careless marketing. The right of possession is famously strong. In Formalities versus Dudley Marshall, the court stated that the mortgagee can take possession before the ink is dry, meaning possession is available once the mortgage is created unless the contract says otherwise. In practice, residential possession is constrained by statute and regulation, but the doctrinal rule is important. Protection of mortgagors include statutory interventions such as Section 36 of the Administration of Justice Act 1970, allowing the court to adjourn or suspend possession proceedings if the mortgagor can pay within a reasonable period. Cheltenham and Gloucester versus Norgan guides that reasonable period may be the remaining mortgage term depending on circumstances. Protection of third parties is critical, especially co-owners with beneficial interests. If a spouse or partner has a beneficial interest and actual occupation, that interest may override and bind a lender, as in Bolland. Lenders respond through overreaching and through obtaining consent. Undue influence is also central in mortgage contexts, where one partner pressures another into guaranteeing or charging the home for the other's debts. The lender may be fixed with constructive notice and required to take steps to ensure informed consent. Authorities like Royal Bank of Scotland versus Ettridge No. 2 set out the steps lenders should take, including ensuring independent legal advice. For SQE, you do not need every detail, but you must spot the risk, a non-commercial surety transaction, relationship of trust and confidence, and the lender's duty to take reasonable steps.
Relationship between landlord and tenant in a lease. A lease is both a contract and a property right. That dual nature is central. The lease creates contractual obligations between the original landlord and tenant, but it also creates a proprietary estate in land that can bind third parties, such as future owners. The landlord grants exclusive possession for a term, and in return the tenant pays rent and performs covenants, such as repair, user restrictions and payment of service charges. The landlord's key obligations may include quiet enjoyment, meaning the tenant's possession should not be substantially interfered with, and non-derogation from grant, meaning the landlord should not take back with one hand what it granted with the other. Essential characteristics of a lease, including the difference between a lease and a license. The leading case is Street v. Mountford. The core characteristics are exclusive possession for a term, usually at a rent, though rent is not strictly essential. Exclusive possession means the tenant can exclude the world, including the landlord, except to the extent entry rights are reserved. If the occupier lacks exclusive possession, it is usually a license, not a lease. A term means a certain duration. It can be fixed, like 5 years, or periodic, like monthly, provided it is sufficiently certain in law. A license is a personal permission to occupy. It does not create a proprietary estate, so it generally does not bind purchases in the same way. Courts look to substance, not labels. A document calling itself a license can still be a lease if the reality is exclusive possession for a term. Equally, courts can disregard sham clauses inserted to pretend the landlord retains control when it does not. Also note the concept of a Bruton tenancy from Bruton v. London and Quadrant, where a tenancy-like relationship can exist even if the landlord lacks a full proprietary estate, showing again that land law often reflects function and policy, not just formal labels. Privity of contract and privity of estate. Privity of contract refers to the original contractual relationship between the original landlord and the original tenant. Historically, that meant that even after assignment, the original tenant might remain liable on covenants because they promised in contract. Privity of estate refers to the relationship between whoever currently holds the lease and whoever currently holds the reversion. It creates mutual enforceability of covenants that touch and concern the land. Modern law has been significantly reshaped for new leases by the Landlord and Tenant Covenants Act 1995. For post-1996 leases, assignment generally releases the outgoing tenant from future liability, reflecting a policy of fairness and commercial reality, while still allowing authorized guarantee agreements in some circumstances. In SQE problems, the examiner may test whether a covenant can be enforced against an assignee, whether the original tenant remains liable, and whether the covenant is the sort that runs with the land.
Rules for the passing of the benefit and burden of leasehold covenants and enforceability.
Leasehold covenants can run with the land through privity of estate, provided they touch and concern the land. A repairing covenant, a user covenant, or a rent covenant typically does. Statutory provisions in the Law of Property Act 1925, such as Sections 141 and 142, assist in transferring the benefit and burden of certain covenants on assignment of the reversion. But you must always check the date of the lease, because the Landlord and Tenant Covenants Act 1995 changes the framework for post-1996 leases, especially around release and continuing liability. The practical solicitor question is always who is the right defendant and who has the right to sue. Is it the original party in contract, the current landlord or tenant in estate, or both? That is where you pick up marks. Purpose and effect of an alienation covenant. Alienation covenants restrict the tenant's ability to assign, underlet, charge, or part with possession. Landlords use them to control who occupies the property and how it is used. Alienation covenants can take different forms. They might be absolute prohibitions, qualified covenants requiring consent, or fully permissive provisions. Where consent is required, landlord and tenant legislation can impose standards of reasonableness. In many commercial settings, landlords cannot unreasonably withhold consent, and they may have duties to respond within a reasonable time. The precise statutory route depends on the covenant wording and context, but for SQE, you should recognize the policy: tenants should not be trapped, and landlords should not be forced to accept unsuitable assignees. The effect of an alienation covenant is often tested through a breach scenario. The tenant assigns without consent or underlets in breach, and the landlord seeks remedies. Remedies for breach of leasehold covenants, including forfeiture. Remedies depend on the covenant and the breach. Landlords may seek damages, injunctions, specific performance for certain obligations, and importantly, forfeiture. Forfeiture is the landlord's right to bring the lease to an end for breach if the lease contains a forfeiture clause. For most breaches other than non-payment of rent, Section 146 of the Law of Property Act 1925 requires the landlord to serve a notice specifying the breach, requiring remedy if it can be remedied, and requiring compensation if appropriate before forfeiture can be enforced. Relief against forfeiture is an equitable remedy that can restore the lease if the tenant remedies the breach, or if it would be unjust to end the lease. Courts are often willing to grant relief, especially for breaches that are capable of remedy and where forfeiture would be disproportionate. For non-payment of rent, landlords may be able to forfeit without a Section 146 notice, depending on the lease and the statutory context, though modern residential law adds layers of protection. Tenants also have remedies against landlords for breach, such as damages for disrepair, injunctions, and in some contexts, rent suspension. Different ways a lease can be terminated. Leases end in several legally distinct ways. A fixed-term lease ends by a fluxion of time when the term expires, unless continued by statute or agreement. A periodic tenancy can be terminated by valid notice to quit, which must usually align with the period of the tenancy and comply with any statutory requirements. A lease can end by surrender, which is a mutual agreement to give up the lease. Surrender can be express, typically by deed, or implied by conduct that is unequivocally inconsistent with continuation, such as the tenant handing back the keys and the landlord taking possession and reletting. A lease can end by forfeiture following breach, subject to the legal and equitable controls we discussed. A lease can end by merger if the same person becomes both landlord and tenant in the same right, so the leasehold estate and freehold estate combine. A lease can also end by operation of a break clause if the clause is properly exercised in accordance with its conditions, which often include strict notice requirements and sometimes conditions such as payment of rent up to date. In answer exams, the mark-winning technique is to name the termination method and then apply its conditions to the facts carefully, especially around notices and Section 146.
Putting the whole specification together. To finish, link the system back to the SQE mindset. When you are told land is registered, the default is that rights should be protected on the register and priority is controlled by the Land Registration Act 2002 with limited overriding interests. When you are told land is unregistered, you think deeds, land charges registration, and the doctrine of notice. When you are told there are co-owners, you think trust of land, legal joint tenancy, beneficial ownership in joint tenancy or tenancy in common, survivorship,
severance, and tollata disputes. When you are told there is a neighbour dispute, you think easements and covenants, their creation, and whether they bind successors. When you are told there is a borrowing secured on the home, you think mortgage creation, priority, possession and sale, duties to obtain proper value, statutory protection for mortgagors, and the vulnerability issues around undue influence and actual occupation. When you are told there is a lease, you think lease versus license, formalities, registration if over 7 years, privity of contract and estate, how covenants run, alienation restrictions, remedies including forfeiture, and termination routes. And throughout, you keep your professional head. You act in the best interests of the client, but you do not cut corners, mislead, or ignore risks that can harm third parties or undermine trust in legal services. The SRA principles are not a separate ethics chapter. They are the baseline operating system for land transactions.
Are you a wine drinker? Even if you aren't, you could still be an investor in wine. Yes, bottles of wine are assets that can be very expensive. Imagine, however, how you would feel if you had a certificate of ownership, you paid for storage and insurance, and you still discovered in insolvency that your Bordeaux is legally just part of someone else's pile. In London Wine, customers paid for specific quantities of wine and received certificates. The wine sat in the company's warehouse, insured and stored, and everyone behaved as if the customers owned it. Then the company went insolvent. The shock. Because the bottles were never segregated or identified, the customers could not establish a trust over their wine, so they were left competing with unsecured creditors. Welcome to this lecture on English Trusts Law for SQE 1 FLK 2. The aim is practical. You are learning the rules, but you are also learning how to apply them as a newly qualified solicitor would. That means you read a fact pattern, you identify the trust or equitable relationship, you test validity, you work out beneficial entitlement, you assess duties and breaches, you consider third-party liability, and you finish with remedies. It also means you keep one eye on professional conduct. Even though the SQE Trusts syllabus is doctrinal, the assessment objectives remind you that you must act honestly and with integrity, and in accordance with the SRA's standards and regulations, including the SRA's principles and the Code of Conduct. In a trusts scenario, that typically shows up in conflicts of interest, handling client money, disclosure duties, and the temptation to smooth over defects in formalities. Equity is obsessed with conscience, so are professional standards. A second framing point matters. Questions can combine topics. You might be asked about an imperfect transfer of shares into trust, a fiduciary who secretly profits, a family home dispute after a relationship breakdown, and a claimant trying to trace funds into property bought in someone else's name. The skill is to treat this as one joined-up problem. With that in mind, we will cover the SRA's specification for FLK Trusts Law in a structured way, helping you prepare for your exam in the best way possible.
Express trusts and implied trusts, the big picture. An express trust is intentionally created. A settlor decides that property should be held by a trustee for beneficiaries or for a charitable purpose. The defining idea is that the trustee holds legal title, but the beneficiaries hold equitable title, and equity will enforce that split. Implied trusts, in modern teaching language, are usually trusts that arise by operation of law rather than by a deliberate declaration. That category includes resulting trusts and constructive trusts. The word implied can be slippery because older materials sometimes use it to mean expressed inferred trust as well. For SQE purposes, the safe approach is this. When the facts show a deliberate intention to create a trust, treat it as express. When the facts show equity stepping in because of contributions, failure of purpose, wrongdoing, or unconscionability, you are usually in resulting trust or constructive trust territory. Now we turn to the creation and requirements of express trusts, beginning with the foundation stone. Creation and requirements of express private trusts, the 3 certainties. To create a valid express private trust, equity requires the three certainties, traditionally linked to Knight v. Knight. The trust must show certainty of intention, certainty of subject matter, and certainty of objects. Certainty of intention asks whether the settler meant to impose a binding obligation rather than make a request, express a hope, or offer a moral wish. Courts use an objective approach. What would a reasonable person understand from the words and context? In Re Adams and the Kensington Vestry, language that the wife was left property in full confidence that she would do the right thing for children was treated as non-binding. It was moral, not legal. By contrast, intention can be found without technical language. In Paul v. Constance, repeated statements that money in an account was as much yours as mine, combined with conduct, was enough to show intention to share beneficially. Intention also has a negative side. Equity will not let you relabel a failed gift as a trust just because the donor wishes it. Jones v. Locke is the classic warning. A father tried to give a cheque to a baby, and the court refused to treat it as a trust. The case is often explained as a policy point. The court will not rescue a defective gift by inventing an intention to declare a trust. Certainty of subject matter asks what property is held on trust and what are the shares or interests. If you cannot identify the trust property, you cannot administer the trust. If you cannot identify each beneficiary's share in a fixed trust, you cannot distribute. Uncertainty about the property can invalidate the trust. In Palmer v. Simmons, the bulk of my estate was too vague. In Re London Wine, purported trusts over unsegregated bottles of wine failed because you could not identify which bottles were trust property. The practical point is segregation. When property is part of a larger bulk, you often need it set aside. However, equity's approach differs depending on the asset. Shares of the same class are often treated as fungible. In Hunter v. Moss, a trust of a fixed number of shares out of a larger holding was upheld even without segregation. The reasoning is controversial, and you should not overgeneralize it, but for SQE-style questions, the exam often expects you to recognize the share fungibility logic and contrast it with Re London Wine. Certainty of objects is about identifying who can benefit. In a fixed trust, the complete list test applies. You must be able to draw up a complete list of beneficiaries. The traditional authority is IRC v. Broadway Cottages. In a discretionary trust, the test is more flexible. In MacPhail v. Dalton, the House of Lords accepted that a discretionary trust is valid if you can say of any given person whether they are on or aren't within the class, sometimes called the is or is not test, associated with Re-Gulbenkian settlements and developed in MacPhail. You also need to handle two additional validity controls that often appear in problem questions. One is conceptual uncertainty. If the concept defining the class is unclear, the trust fails. Words like friends can be dangerously vague. Another is administrative unworkability. Even if conceptually clear, a class can be so wide that trustees cannot sensibly perform the duty. The classic illustration is a trust for all the residents of Greater London. Courts have flagged this issue, and you often see it discussed alongside Re Manistys settlement, where capriciousness is also mentioned. The exam skill is to recognise when the class definition is so broad that administration collapses. With those foundations, we can now separate fixed interest trusts from discretionary trusts, because the rules and the litigation issues differ.
Fixed interest trusts. A fixed interest trust is one where the beneficial shares are fixed by the trust instrument. The trustees have no discretion about who gets what. Their job is to hold, manage, and distribute as directed. Fixed trusts are attractive because they are predictable. They can also be brittle. If the shares are uncertain, the trust fails. This is where you see cases about uncertainty of beneficial shares, and why subject matter is not only about what property, but also who gets what. When advising in practice, fixed trusts often raise questions about vesting. A gift may be vested in interest, but not vested in possession. For example, to A for life, remainder to B, gives B a vested remainder from the start, even though B only possesses later. That matters for death, bankruptcy, and the ability to collapse the trust. A fixed trust also interacts strongly with the rule in Saunders v. Vautier.
If all beneficiaries are adult, have capacity, and are absolutely entitled, they can demand the trust property and end the trust early. We will return to that rule under beneficial entitlement. Discretionary trusts. A discretionary trust gives trustees a discretion about who benefits and in what amounts within a defined class. The beneficiaries do not have fixed shares until trustees exercise their discretion. Instead, beneficiaries have a right to be considered and a right to enforce proper exercise of discretion. The validity test for objects is therefore less strict than in fixed trusts. The is or is not test from McPhail v. Dalton reflects a practical reality. Trustees do not need a complete list to exercise discretion, but they must be able to decide whether a claimant is within the class. In problem questions, discretionary trusts frequently raise a different kind of dispute. A disappointed potential beneficiary challenges the trustee's decision as procedurally flawed. The court will not normally substitute its own discretion, but it can intervene if trustees act in bad faith, fail to consider relevant matters, consider irrelevant matters, or act outside of the scope of the trust. This is where equity's control of fiduciaries blends into trust administration. Trustees must exercise discretionary powers for proper purposes and with attention to the trust's aims. In a solicitor-style answer, you make that explicit. The discretion is wide, but not unlimited.
Formalities to create express inter vivos trusts. Formalities ask whether a particular form must be used for the trust to be valid or enforceable. For inter vivos trusts, you look first at the nature of the property. For land, Section 53(1)b of the Law of Property Act 1925 requires that a declaration of trust of land must be manifested and proved by some writing signed by the person able to declare it. This is an evidential requirement, not necessarily a validity requirement. In other words, an oral declaration may create a trust, but without signed written evidence, you cannot enforce it in court. That distinction matters in exam questions because it allows equity to say, in effect, the trust exists, but you cannot prove it in the required way. There is also an equitable safety valve. Equity will not allow a statute to be used as an instrument of fraud. Rochefoucauld v. Bousted is often cited for the idea that if someone obtains title on the understanding they will hold on trust, they cannot later rely on lack of writing to deny the trust. The reasoning is sometimes criticized, but for SQE you should recognize the principle and apply it carefully. For other property, formalities depend on the transaction, not on trusts law alone. Shares require proper transfer mechanisms, often involving stock transfer forms and registration. Shows in action may require written assignment under Section 136 of the Law of Property Act 1925 for a legal assignment, but equitable assignment can exist with less formality. The SQE question will usually tell you what steps were taken, and you match those steps to the relevant property type. Constitution is different from formalities. Formalities ask whether the trust is in the right form. Constitution asks whether the trust property has actually been transferred or otherwise vested so that the trust is fully effective. If the settlor declares themselves trustee, the trust can be constituted without any transfer because legal title is already with the settlor. But if the trust requires transfer to third-party trustees or is structured as an outright gift to trustees on trust, then the transfer must be completed. The classic principle is from Milroy v. Lord. Equity will not perfect an imperfect gift. If the donor has not done what is necessary to transfer property, equity will not step in to complete it, because equity will not assist a volunteer. The intended beneficiary who gave no consideration cannot force completion. This is a harsh rule, so you need the recognized exceptions and edge cases. One is the rule in Re Rose. If the donor has done everything in their power to transfer the property, then equity may treat the transfer as effective in equity, even if some administrative step remains, such as registration by a company. The logic is that it would be unconscionable for the donor to retract once they have put the transfer beyond their own control. Another is Strong v. Bird.
If the donor intends to make an immediate gift and that intention continues, and the intended donee becomes the donor's executor, the gift can be perfected on death because the legal title vests in the donee as executor. The rule has been extended beyond its original narrow setting, and you should look for it in wills-style fact patterns where a donor promised a gift, then appointed the person as executor. Another is donatio mortis causa, a deathbed gift. The donor must contemplate imminent death, make the gift conditional on death, and deliver dominion over the subject matter. Sen versus Headley is a leading modern case, including the idea that handing over keys to a box containing title deeds can sometimes amount to sufficient dominion. Deathbed gifts are exceptional and fact-sensitive. In SQE questions, the examiners often signal it by explicitly describing imminent death and conditional language. Then there is the controversial line of authority associated with Pennington versus Wayne, where the Court of Appeal focused on unconscionability. It treated an imperfect transfer of shares as effectively complete in equity because it was unconscionable for the donor to retract. The difficulty is that unconscionable can become vague. In exam answers, you acknowledge Pennington, but you also explain that it sits uneasily with Milroy versus Lord and Re Rose, and that courts have been cautious about expanding it. You should also be alive to Choithram versus Pagarani, where the Privy Council upheld a gift to a foundation when the donor was one of the trustees. The reasoning is sometimes explained as treating the donor as having declared himself a trustee of the property for the charitable foundation, even though the transfer mechanics were incomplete. Again, it illustrates equity's willingness to construe words to save a trust where possible, particularly in charity contexts, but without openly abandoning Milroy versus Lord. In a solicitor-style analysis, you do not merely recite cases, you classify the situation. If it's a self-declaration, constitution is not the problem. If it's a transfer to trustees, you check if transfer was completed. If not, you ask whether Re Rose applies, whether Strong versus Bird applies, whether a deathbed gift is plausible, and whether any unconscionability argument is likely.
Beneficial entitlement, fixed, discretionary, vested and contingent interests. Beneficial entitlement describes what the beneficiary owns in equity. Trusts law uses language that sounds technical, but the idea is intuitive. You ask, does the beneficiary have a defined share, or only a chance of benefiting? Has the interest vested, or is it still conditional? A fixed interest is straightforward. The trust instrument specifies the entitlement. If A is entitled to the income for life, A has a life interest. If B is entitled to the capital at age 25, B has an interest that may be contingent until the age condition is satisfied, depending on drafting. A discretionary interest is not a fixed share. A member of a discretionary class has a right to be considered and a right to challenge improper exercise, but not a right to demand distribution. This distinction matters when you advise on bankruptcy, divorce, creditor claims, and whether an interest can be assigned. Vested and contingent language can be confusing, so anchor it to enforceability. A vested interest is one that belongs to the beneficiary now, even if enjoyment is postponed. A contingent interest depends on a condition precedent. For example, to B if B marries is contingent until marriage happens. To B at 25 is often treated as contingent until 25, though some drafting can create a vested interest subject to divestment instead. In exam questions, the simplest approach is to treat age conditions as contingent unless the question gives you reasons to interpret differently. These distinctions connect directly to Saunders and Vautier, because only beneficiaries who are absolutely entitled can collapse the trust.
The rule in Saunders v. Vautier. Saunders v. Vautier established that if a beneficiary is of full age, has mental capacity, and is absolutely entitled to the trust property, they can demand that the trustees transfer it to them, ending the trust. The trustees cannot insist on continuing to administer merely because the settlor wanted the property held until a later time. The most important practical extension is that if there are multiple beneficiaries, they can collectively do the same thing if they are all adult, have capacity, and together are absolutely entitled to the whole beneficial interest. If even one beneficiary is a minor, lacks capacity, or holds a contingent interest that has not yet vested, the rule will not allow collapse. This rule matters in client advice. A settler might think they can lock up assets until a child is 30, but if the drafting gives the child an absolute vested interest at 18, with only postponed enjoyment, the child may be able to force distribution. Conversely, careful drafting using contingent interests or discretionary structures can prevent early collapse. In exam answers, you state the rule, then you apply it to the facts by testing age, capacity, and whether the interest is absolute. If the trust is discretionary, Saunders v. Vautier usually does not apply because no one is absolutely entitled until trustees exercise the discretion.
The distinction between charitable trusts and non-charitable purpose trusts. This topic turns on a core principle of private trusts, the beneficiary principle. Morris v. Bishop of Durham is the classic statement: there must be identifiable beneficiaries who can enforce the trust. If a trust is for a purpose rather than for persons, it usually fails because no one has standing to enforce. Charitable trusts are the major exception. A charitable trust is a purpose trust, but it is valid because it serves purposes recognized as charitable and provides public benefit, and it is enforceable through public mechanisms, traditionally involving the Attorney General and, in modern administration, the Charity Commission. The Charities Act 2011 is the main statutory framework, describing recognized heads of charity and emphasizing public benefit. Non-charitable purpose trusts, meaning private purpose trusts, are generally void. Re Astor's settlement trusts is a well-known example, where vague purposes like promoting international understanding were held invalid. Re Endicott is another important authority, emphasizing that purpose trusts, outside narrow exceptions, are not allowed. There are, however, anomalous exceptions, often described as trusts of imperfect obligation. They include trusts for the maintenance of specific animals, often associated with Re Dean, and trusts for maintenance of graves in monuments in certain conditions. These exceptions are narrow, fact-specific, and constrained by perpetuity concerns. A more modern and exam-friendly way to handle borderline cases is through Re Endley's trust deed. The trust there was framed as a purpose, a recreation ground, but it directly benefited identifiable people, employees, who could enforce it. Many commentators treat Re Endley as not truly a purpose trust at all, but a trust for persons with a purpose attached. For SQE purposes, that is the key insight. If identifiable individuals benefit and can enforce, the trust may survive even if the drafting sounds purposive. So the distinction you should articulate is this. Charitable trusts are enforceable purpose trusts because of public benefit and public enforcement. Non-charitable purpose trusts are generally void because of the beneficiary principle, unless they fit into very narrow exceptions or are recharacterized as trusts for persons. Resulting trusts arise when the law concludes that the recipient should not take beneficially, so the beneficial interest results back to the transferor or the transferor's estate. The two main categories are presumed resulting trusts and automatic resulting trusts. A presumed resulting trust often arises where A transfers property to B gratuitously or contributes to the purchase price of property put in B's name, and the law presumes A did not intend to make a gift. Dyer v. Dyer is a classic purchase money resulting trust authority. The presumption is evidential, meaning it can be rebutted by evidence that A intended a gift or loan. A major counter-presumption is the presumption of advancement. Historically, certain relationships, such as parent to child, could presume a gift rather than a trust. Modern law has heavily questioned and narrowed that presumption, and in many contexts, courts prefer to look at actual intention and the whole relationship, particularly in family home disputes, where Stack v. Dowden and Jones v. Kernot shape analysis. An automatic resulting trust arises when an express trust fails in whole or in part. The settler did intend a trust, but the trust does not effectively dispose of the beneficial interest. For example, if a trust is declared for a non-charitable purpose and is void, the property may return to the settler on resulting trust. Similarly, if a trust is declared for A for life, but does not dispose of the remainder can result back.
The theoretical explanation has been debated. In Westdeutsche Landesbank v. Islington LBC, the House of Lords discussed resulting trusts in the context of mistaken payments and a need for a sufficient equitable interest. Lord Brown Wilkinson emphasized conscience and knowledge. Later, in Air Jamaica v. Charlton, Lord Millett described resulting trusts as arising because the recipient is not intended to benefit, emphasizing the absence of intention to benefit rather than any retained beneficial interest. For SQE, you do not need to master the jurisprudential debate, but you should be able to explain that resulting trusts often reflect the law's inference that beneficial entitlement has not passed. One special and frequently examined resulting trust type is the Quist-Close Trust from Barclays Bank v. Quist-Close Investments. Money is advanced for a specific purpose, such as paying creditors. If the purpose fails, the money is held on resulting trust for the lender. The issue is usually whether the money was meant to be at the free disposal of the borrower, which would create a debtor-creditor relationship, or whether it was segregated and purpose-limited, which supports a trust analysis. When advising, always ask, was there an intention to benefit the recipient? Was the transfer gratuitous? Was there a purpose that failed? Was the money segregated? Those factual levers typically decide the resulting trust outcome.
Trusts of the family home. Family home trusts are where trust's law meets real life. The dispute is usually between cohabitees or spouses after a relationship breakdown. One person may hold legal title, but the other claims a beneficial share. The modern framework is dominated by constructive trust analysis based on common intention and, in many cases, supplemented by proprietary estoppel principles. You must start with legal title. Is the legal title in joint names or in one name only? That choice changes presumptions and the path of reasoning. When legal title is in joint names, the starting presumption is that equity follows the law, meaning the beneficial interest is also joint. Stack v. Dowden established that the presumption can be rebutted if the party's whole course of conduct shows a different common intention. Jones v. Kernot developed the approach further, accepting that courts may infer or in some cases impute an intention to shares where it is clear the parties intended to share but unclear what the shares were. In practice, for joint legal title, you look at factors like contributions to purchase price, mortgage payments, arrangements for finances, children, and how the parties understood ownership. The modern approach resists a purely arithmetic analysis. It is contextual. When legal title is in one name only, the claimant must usually establish a common intention constructive trust by showing two things. First, that there was a common intention that the claimant should have a beneficial interest. Second, that the claimant acted to their detriment in reliance on that intention. This structure is strongly associated with Lloyds Bank v. Rossett, where Lord Bridge suggested that common intention can be shown either by an express agreement, arrangement, or understanding, or, in the absence of express discussion, by direct contributions to the purchase price. Rossett has been heavily criticised as too narrow, and later cases have softened it, but for SQE purposes, Rossett remains an anchor authority. You should recognise both routes and then apply later contextual reasoning where appropriate, especially when the facts show sustained financial integration beyond simple deposit payments.
Legal title in the name of both parties and in the name of a sole party. Joint legal title cases often begin with the presumption of equal beneficial shares, then move to rebuttal. Stack v. Dowden is the key authority, and it emphasises that the presumption is strong but not irrebuttable. Jones v. Kernot then shows how courts deal with changing intentions over time, including separation and divergent contributions. Sole legal title cases often begin with no presumption of shared beneficial ownership. The claimant must establish it. Cases like Grant v. Edwards and Eves v. Eves are classic illustrations of courts inferring common intention from conversations and conduct and then finding detriment through contributions and labour. The solicitor's task in these cases is evidence. What was said, when and in what terms? What was paid, by whom and from what source? Was there reliance and did it cause detriment? In exams, you narrate those questions and you answer them using the facts you are given. Express declaration or agreement as to equitable ownership. An express declaration of trust is a powerful piece of evidence, where the parties execute a written declaration stating the beneficial shares. The courts generally treat that as conclusive, subject to limited exceptions like fraud, mistake, or undue influence. This is why conveyances take declarations of trust seriously, and why SQE scenarios sometimes include a TR1 form or similar document. If there is an express oral agreement but no formal declaration, the position is more complex. For sole name cases, an express agreement can establish common intention, but you still need detrimental reliance. The agreement must be sufficiently clear to infer that the claimant was meant to have an interest, not merely that the parties would share everything in a vague way. In exam answers, you quote or paraphrase the words, and you show how they meet or fail the common intention threshold. Direct and indirect contributions. Direct contributions are the traditional Rosset route. These include paying the deposit, paying mortgage installments, or paying significant sums directly linked to acquisition. Courts treat these as strong evidence of an intention to share beneficially. Indirect contributions are more contested. Paying household bills can free up the legal owner's income to pay the mortgage. Doing extensive renovations can increase value. Caring responsibilities can also affect financial arrangements. Modern case law shows greater willingness to view the relationship holistically, especially in joint name cases, and to recognize that families organize finances in diverse ways. However, you must be disciplined in how you apply this in an SQE answer. In sole legal title cases, if the claimant has only paid general household expenses with no clear link to acquisition, Rosset suggests difficulty. If the claimant has evidence of an express understanding, or if the expenditure is substantial and clearly connected to enabling acquisition or improvement, you can argue that the intention and detriment requirements are satisfied. If the claimant's contribution is mainly non-financial domestic labour, you should treat it as supporting evidence of reliance and detriment, but be cautious about presenting it as automatically sufficient without more, because courts vary and the exam expects measured reasoning. If the exam wants you to emphasise modern flexibility, you can reference that. Stack v. Dowden and Jones v. Kernot illustrate a broader evaluative approach, even though the strict Rosset language lingers. The safest exam posture is direct contributions are strongest. Indirect contributions can support a claim, especially with other evidence, but are more fact-sensitive. You must also be up to date with Hudson v. Hathaway 2022. This case clarified two vital points for practice. First, even in joint names cases where parties are arguing about changing their beneficial shares, the claimant must show detrimental reliance on the common intention. It is a core requirement of the constructive trust. Second, in our digital age, an email chain can sometimes amount to a signed disposition of an equitable interest. Typing your name at the bottom of an email can satisfy the statutory signature requirement, meaning parties might inadvertently settle their shares by email.
Requirements to establish proprietary estoppel. Proprietary estoppel is often described as equity's response to unconscionability, where one person has been led to believe they will have rights in property, acts to their detriment, and it would be unjust to deny them. The classic formulation uses three elements: an assurance, reliance, and detriment, with unconscionability as an overall control. Cases like Gillett v. Holt and Thorner v. Major show that the assurance can be implied from conduct and need not be a formal promise. It must, however, be sufficiently clear in context. Cobb v. Yeoman's Row highlights that in commercial negotiations, proprietary estoppel is harder to establish if parties know they have not reached a binding agreement and still proceed. Detriment is interpreted broadly. It can include expenditure, labour, giving up opportunities, caring work, or otherwise changing one's position. The key is that it must be something substantial enough that it would be unjust to deny relief. Remedy in proprietary estoppel is flexible. The court aims to satisfy the equity, not necessarily to give the claimant everything promised. Jennings v. Rice is often used to show proportionality.
In modern Supreme Court authority, like Guest v. Guest, the Court again emphasised that remedies can range from transfer of property to monetary awards or life interests, depending on what is necessary to avoid unconscionable harm. In family home problems, proprietary estoppel can be pleaded alongside constructive trust. As a solicitor, you often plead both routes, and for SQE analysis, you explain both routes and conclude which is stronger on the facts. Liability of strangers to the trust. Establishing recipient liability. Trusts law is not only about trustees. A third party may receive trust property transferred in breach of trust. Equity may impose liability on that recipient. This is commonly called knowing receipt, and it is traditionally traced back to Barnes v. Addy. To establish recipient liability, you typically need a disposal of trust property in breach of trust, beneficial receipt by the defendant, and knowledge making it unconscionable for the defendant to retain the benefit. The language of unconscionability is prominent in BCCI v. Akindele, which sought to simplify earlier debates about 5 levels of knowledge. Older cases, like Re Montague's settlement, show a stricter approach, where mere notice of the trust may not be enough if the recipient did not appreciate the breach. The overall direction of travel is that equity asks whether, given what the recipient knew, it would be unconscionable to keep the property. The remedy can be proprietary or personal. If the recipient still holds the property, the claimant may seek a proprietary remedy to recover it, subject to defences like bona fide purchaser for value without notice. If the property has been dissipated or cannot be recovered, the claimant may seek a personal remedy, requiring the recipient to account for value. In exam answers, be careful with the bona fide purchaser defence. A purchaser for value without notice takes free of equitable interests, but this defence is not available to volunteers. This links back to the maxim that equity will not assist a volunteer. Equity is harsher to gratuitous recipients.
Liability of strangers to the trust. Establishing accessory liability. Accessory liability is also associated with Barnes v. Addy, traditionally known as knowing assistance. Here, the third party does not necessarily receive trust property. Instead, they assist in a breach of trust. The modern leading authority is Royal Brunei Airlines v. Tan, where the Privy Council emphasised dishonesty. A person is liable if they dishonestly assist a breach of trust. The focus is on the assistant's dishonesty, not on whether the trustee was dishonest. This is important because trustees can breach trust innocently through negligence, while a third party can still be dishonest in helping. Dishonesty has been refined through later cases. Twin Sectra v. Yardley discussed combined subjective and objective elements and created confusion. Later decisions, including Barlow Close v. Eurotrust and the modern criminal and civil dishonesty approach associated with Ivy v. Genting, have pushed towards an objective assessment based on the defendant's knowledge of facts and the standards of ordinary decent people. Following recent case law, the confusion of Twin Sectra is gone. Following Group 7 v. Nasir, the test mirrors Ivy v. Genting. You ascertain the defendant's actual state of knowledge, subjective, and then apply an objective standard. Would an ordinary decent person consider that conduct dishonest given what they knew? Dubai Aluminium v. Salam is important because it clarifies that constructive trustee language is sometimes misleading. The third party may be personally liable to account, even if they never became a trustee of property. You should use precise language. Accessory liability is personal, arising from dishonest assistance, and it leads to an account of loss or profits depending on the claim. In problem questions, accessory liability often involves professionals. Accountants, solicitors, bankers, or advisors may be alleged to have assisted. The exam expects you to identify the relevant mental element and to apply it to what the professional knew and did.
The fiduciary relationship and its obligations. A fiduciary relationship is a relationship of trust and confidence where one party has undertaken to act for another and must act loyally. Trustees are fiduciaries, but fiduciary duties also apply to directors, agents, partners, and solicitors. Fiduciary obligations are not primarily about competence, they are about loyalty. That is why fiduciary duties are strict. A fiduciary must not profit from the position without informed consent. A fiduciary must avoid conflicts of interest. A fiduciary must not place themselves in a position where duty and interest conflict. These duties are often called the no-profit rule and the no-conflict rule. They overlap. They are also prophylactic. They apply even if the fiduciary acted honestly, even if the principal suffered no loss, and even if the fiduciary's conduct benefited the principal. The strictness is illustrated by Boardman v. Phipps. A fiduciary obtained information through their role, pursued an opportunity, and generated profit. Even though the trust benefited, the fiduciary had to account, subject to an allowance for skill and effort. The core message is that fiduciaries cannot unilaterally decide that profit-taking is acceptable. Now we apply these general principles to the specific fiduciary rules identified in the specification. Duty not to profit from a fiduciary position. The no-profit rule means that a fiduciary must account for unauthorized profits made because of the fiduciary position. The profit can be direct, like a commission, or indirect, like a business opportunity. FHR European Ventures v. Cedar Capital Partners is central in modern law. The Supreme Court held that bribes and secret commissions received by an agent are held on constructive trust for the principal. That matters hugely for remedies because a constructive trust enables proprietary claims and tracing. It also matters for insolvency because trust property is separated from the fiduciary's own assets. In exam scenarios, you will often be told that a trustee or advisor received a commission or took a referral fee or accepted a gift. Your analysis is, unless fully informed consent was obtained, this triggers fiduciary liability. The remedy can include an account of profit and sometimes a constructive trust over the profit.
Trustees not to purchase trust property. This is the self-dealing rule. Trustees must not buy trust property, either directly or indirectly, unless expressly authorized or unless fully informed consent is obtained from all beneficiaries who are competent and entitled. The key point is that the transaction is voidable at the instance of the beneficiaries. It can be set aside even if the price was fair. The concern is not only undervalue, it is the conflict of interest. There is also the fair dealing rule, which is related but distinct. It deals with trustees purchasing a beneficiary's interest in the trust, rather than purchasing trust property itself. That can be valid, but only if the trustee can prove full disclosure, absence of pressure, and a fair price. The burden is on the fiduciary. The underlying idea is again loyalty and protection against exploitation. In practice, solicitor advisors must be alert. If a trustee client proposes to buy a trust asset, the conflict is immediate and independent advice is essential. Fiduciary not to put himself in a position where his interest and duty conflict. This is the no-conflict rule. It is broader than self-dealing. It captures situations where the fiduciary has a personal interest that might influence decisions, even if no profit has yet been made. For trustees, conflicts arise with investments, loans, contracts for services, and decisions about distributions if trustees are also beneficiaries. Many trust instruments authorize certain conflicts, such as allowing a trustee beneficiary to participate, but the trustee must still exercise powers in good faith for proper purposes. The key exam message is strictness. The court's aim is to prevent temptation. Once conflict exists, the fiduciary must either avoid the transaction or obtain fully informed consent.
Trustees, who can be a trustee, and appointment, removal, and retirement of trustees. A trustee can be an individual or a trust corporation. Capacity matters. Generally, an adult with mental capacity can be a trustee. Minors cannot act as trustees because trusteeship involves legal title and responsibilities that require capacity. Under S20 LPA 1925, the appointment of a minor as a trustee is void. Trust corporations are often appointed for professional administration.
Appointment can be governed by the trust instrument. If the trust instrument is silent or the appointment mechanism fails, statutory powers fill the gap. The Trustees Act 1925 is central, particularly Section 36, for appointment of new trustees in specified events like death, incapacity or refusal to act. The Court also has power under Section 41 of the Trustees Act 1925 to appoint trustees where it is expedient. Retirement is governed by the trust instrument or by statute. Section 39 of the Trustees Act 1925 allows a trustee to retire if the appropriate deed is executed and usually if there will remain the necessary number of trustees. Removal can occur through the trust instrument, statutory powers, or the court's inherent jurisdiction. The court's guiding principle is the welfare of beneficiaries and the proper administration of the trust. Letterstead v. Browers is commonly cited for that focus. The court does not remove trustees lightly, but it will remove them where conflicts, hostility, incompetence, or misconduct threatens proper administration. A modern practical point is that trusts of land often require at least 2 trustees to allow overreaching on sale, because overreaching under the Law of Property Act 1925 requires payment to at least 2 trustees or a trust corporation. In co-ownership disputes, the Trusts of Land and Appointment of Trustees Act 1996 often frames the litigation, but for FLK law you mainly need to recognize the trustee appointment structure and why trustee numbers matter. Trustees' duty of care. The Trustees Act 2000 modernized and clarified trustee duties, including a statutory duty of care. Section 1 of the Trustees Act 2000 sets the standard. A trustee must exercise such care and skill as is reasonable in the circumstances, having regard to any special knowledge or experience the trustee has or holds themselves out as having, and, if acting professionally, to the standards reasonably expected of a person acting in that professional capacity. That means professional trustees are judged by a higher standard. It also means that a trustee cannot hide behind inexperience if they hold themselves out as competent. The duty of care applies to many trustee functions, including investment, delegation, and management decisions. It does not necessarily apply to every discretionary distribution decision in the same way, but trustees must still act in good faith and for proper purposes in exercising dispositive powers. In exam answers, make the duty of care concrete. Ask what a reasonable trustee would do. Would they take advice? Would they document reasons? Would they review investments periodically? Would they avoid concentration risk? Would they comply with the trust instrument's constraints? Trustees' duty to invest and powers in relation to investment. Investment is a core trustee function. Modern trusts often exist primarily to hold and invest assets. The Trustees Act 2000 gives trustees a general power of investment subject to any restriction in the trust instrument. Trustees must apply the statutory investment criteria, which include suitability and diversification. Trustees must consider whether a proposed investment is suitable for the trust, and they must consider the need for diversification insofar as appropriate. Trustees must also keep investments under review. Trustees are generally expected to obtain and consider proper advice unless it is unnecessary or inappropriate. The exam will often signal this by describing trustees investing in a friend's business, putting all funds into one speculative asset, or refusing to take advice. Those facts are designed to trigger breach analysis. You should also be aware of the ethical investment debate. Cowan versus Scargill remains the starting point for private trusts. Maximize financial returns. However, for charitable trusts, the law has evolved. In Butler-Sloss versus Charity Commission 2022, the court clarified that charity trustees can decide to exclude investments that conflict with their charitable purposes. For example, an environmental charity excluding fossil fuel stocks, even if that risks a lower financial return. They must balance the financial loss against the reputational damage and conflict with their mission. Trustees' statutory powers of maintenance and advancement. Trustees often manage trusts for children or young adults. Statutory powers address how trustees can use income or capital for the beneficiary before the beneficiary becomes entitled in possession.
The Trustees Act 1925, particularly sections 31 and 32, is traditionally cited for maintenance and advancement. The maintenance power allows trustees to apply income for the maintenance, education, or benefit of a beneficiary who is a minor or otherwise not entitled to income outright. The advancement power allows trustees to apply capital for the advancement or benefit of a beneficiary, traditionally up to a proportion, subject to the terms of the trust instrument and any statutory modifications. In problem questions, you're often asked whether trustees can pay for school fees, university fees, housing deposits, or medical expenses. The analysis is, check the trust instrument first. If it grants express powers, apply them. If it is silent, consider statutory powers. Then apply trustee duties. Act in the beneficiary's best interests, act even-handedly where multiple beneficiaries are affected, and document decision-making. A common exam twist is that advancement may prejudice other beneficiaries, such as remainder beneficiaries. Trustee must consider that. Their discretion is not unlimited. They must weigh interests fairly.
Trustee's liability. Breach of trust. A breach of trust occurs when a trustee acts outside powers, fails to comply with duties, or misapplies trust property. Breach can be deliberate or negligent. Liability is usually strict in the sense that trustees are responsible even if they acted honestly, though relief mechanisms exist. Breaches include unauthorized investments, improper distributions, failure to safeguard assets, failure to obtain advice when required, and conflicts of interest leading to improper decisions. Breach also includes misapplication of trust property, such as paying trust money to the wrong person. When answering exam questions, classify the breach. Is it a breach of fiduciary duty, like conflict and unauthorized profit? Is it a breach of the duty of care, like negligent investment? Is it a breach of trust instrument terms, like distributing capital when only income distributions are permitted? The classification helps you identify remedies.
Trustees' liability. Measure of liability. The measure of liability depends on the remedy. Equity aims to restore the trust fund to the position it would have been in but for the breach, or to strip profits where fiduciary obligations were violated. For loss-based claims, trustees may be required to pay equitable compensation, sometimes discussed as reconstitution of the trust fund. Key modern cases include Target Holdings v. Redferns and AIB Group v. Mark Redler. These cases emphasize causation and the scope of duty. Equity does not automatically award the full sum involved in the transaction if the loss would have occurred anyway, or if the breach did not cause the loss in the relevant sense. This is a significant modern development because older descriptions of trustee liability sometimes sounded absolute. The current approach is more nuanced. Equity still protects the trust, but it aligns compensation with causal responsibility. For profit-based claims, trustees may have to account for profits, even if the trust suffered no loss. This is common for fiduciary breaches. The logic is deterrence and loyalty, not compensation. Boardman v. Phipps is a key illustration, and FHR strengthens the proprietary dimension where bribes and secret commissions are involved. In exam answers, be explicit. If trust property was misapplied and the trust lost money, you discuss equitable compensation and reconstitution. If the trustee made a profit through conflict or commission, you discuss account of profits and possibly constructive trust.
Trustees' liability. Protection of trustees. Trustees have protections, and exam questions frequently test them. One protection is beneficiary consent. If a fully informed beneficiary with capacity consents to a breach, they may be unable to complain later. But consent must be genuine, informed, and free from pressure. Consent also cannot usually bind beneficiaries who lack capacity, such as minors, unless a court approves. Another protection is exemption clauses in the trust instrument. Armitage v. Nurse is central. It held that an exemption clause can exclude liability for negligence and even gross negligence, but it cannot exclude liability for fraud. The irreducible core of trusteeship is honesty and good faith. That principle is regularly examined.
A third protection is statutory relief under Section 61 of the Trustee Act 1925. The court may relieve a trustee from personal liability if the trustee acted honestly and reasonably and ought fairly to be excused. This is discretionary. Trustees cannot assume it will apply. But in exam questions where trustees made an innocent mistake after taking advice, Section 61 is a plausible argument. Professional trustees and solicitors should be cautious here. The more professional the trustee, the harder it is to argue that mistakes were reasonable. Documentation and advice-taking become key.
Trustees' liability. Limitation period. Limitation in trusts claims is governed by the Limitation Act 1980, with special rules for trusts claims. The headline point is that some breaches are not subject to ordinary limitation periods, especially where trustees are fraudulent or where they retain trust property. Section 21 of the Limitation Act 1980 is central. Claims against a trustee for fraud or to recover trust property or its proceeds in the trustee's possession are generally not barred by limitation. For other breaches, the normal limitation period, often 6 years, may apply. This matters in practice because beneficiaries sometimes discover problems long after the event. In exam questions, if time is mentioned, you should immediately consider whether the breach involved fraud or misappropriation and whether the trustee still holds the property or its traceable proceeds.
The nature of equitable remedies. Equitable remedies are distinctive because they are discretionary and conscience-based, even though they are applied through structured rules. They include proprietary remedies, personal remedies, and specific forms of relief like injunctions and specific performance. In trusts, the core equitable remedies include orders compelling trustees to account, orders to restore trust property, rescission of transactions tainted by breach of fiduciary duty, injunctions to prevent dissipation, and declarations of constructive trust. You should also be comfortable distinguishing common law damages from equitable compensation. Equitable compensation is the trust-focused remedy for breach of trust and breach of fiduciary duty leading to loss. It aims at reconstitution, but modern cases require attention to causation. Another distinctive equitable remedy is an account of profits used to strip unauthorized gains. This is central to fiduciary law and can be available even without loss. Rescission is important for self-dealing and conflict transactions. The beneficiary may set aside the transaction, subject to bars such as affirmation, delay, or third-party rights. Equity's discretionary nature shows up here. Delay can be fatal if rescission would unfairly prejudice others. In injunction problems, equity can restrain conduct, including freezing injunctions in some contexts, though the detailed civil procedure is beyond this trust syllabus. Still, the exam may include a scenario where beneficiaries want urgent relief to stop dissipation. Your trust law contribution is to identify the equitable basis for restraining breach and preserving assets. The availability of tracing in equity. Tracing is not a remedy by itself, it is a process. It allows a claimant to identify what happened to property and to claim it in its substituted form or claim value from those who hold it. You should separate 3 ideas. Following tracks the same asset as it moves from person to person. Tracing tracks value as it changes form, for example when money is used to buy shares or land. Claiming is the step where the claimant asserts a right over the traced asset, such as a constructive trust or equitable lien. Equitable tracing is more flexible than common law tracing because equity allows tracing through mixtures. Common law tracing traditionally fails once money is mixed in a bank account because the original notes and coins are no longer identifiable. Equity, by contrast, treats the mixed fund through presumptions and rules. Re Hallett's estate is a leading authority. It created the presumption that a trustee who mixes trust funds with personal funds is presumed to spend their own money first. This protects beneficiaries by leaving trust money in the account as long as possible. Re Otway is another key case. It prevents a trustee from arguing that trust money was spent first where doing so would harm beneficiaries. If the trustee used mixed funds to buy an asset, beneficiaries may claim that asset as representing trust money, rather than being forced to accept whatever remains in the account. Where funds are mixed and then dissipated, the lowest intermediate balance rule limits recovery. The idea is that you cannot trace into an account more than the lowest balance after the misappropriation, because once money is spent, it is gone. This is often linked to cases like James Roscoe Bolton v. Winder. Where multiple innocent claimants' funds are mixed, different rules can apply, including pari passu sharing in some contexts or the rule in Clayton's case in others, though modern courts are cautious about Clayton because it can produce arbitrary outcomes. For SQE, the most common expectation is that you recognize the basic wrongdoer mixing rules from re Hallett and re Otway and the proportionality approach where multiple victims are involved. Foskett v. McEwen is an important modern case, illustrating choice of remedy when trust funds are used with other funds to acquire an asset, such as paying premiums on a life insurance policy. The beneficiaries could claim a proportionate share of the payout, reflecting their contribution. The key idea is that proprietary remedies are not limited to compensation. They give claimants a share in gains. Tracing also interacts with subrogation. If trust money is used to pay off a secured debt, such as a mortgage on a property, equity may allow the beneficiaries to be subrogated to the lender's security rights. In simple terms, the beneficiaries step into the lender's shoes to the extent necessary to prevent unjust enrichment. Finally, you should be aware of backward tracing, recognized in a more developed way in the Privy Council decision in Federal Republic of Brazil v. Durant International. The idea is that where there is a close causal link between the incurring of a debt used to acquire an asset and the later misappropriation used to pay that debt, tracing may operate backwards to connect the misappropriated funds to the asset. This is complex, but in exam questions it is usually signposted. If the scenario involves a chain of borrowing and later repayment with misappropriated funds, you mention backward tracing as a possible equitable approach where causally linked.
Conclusion. The exam approach that works. Trusts law for SQE is not about memorizing isolated rules. It is about moving through a structured analysis in a client-focused way. You begin with creation. Is there an express trust? Do the three certainties work? Are formalities satisfied? Is the trust constituted, or is it an imperfect transfer where equity may or may not assist? You then identify beneficial entitlement. Is it fixed or discretionary? Is it vested or contingent? Can the beneficiaries invoke Saunders v. Vautier? You then classify implied trusts when appropriate. Is there a resulting trust because beneficial entitlement did not pass or because a purpose failed? Is there a constructive trust because of common intention in a family home or because of wrongdoing? You then examine trusteeship. Who can be a trustee? How a trustee is appointed, retired, or removed. What duties and powers apply, especially duty of care, investment, maintenance, and advancement. You then examine liability. Was there breach of trust or breach of fiduciary duty? What is the measure, loss-based or profit-based? What protections exist, including exemption clauses, beneficiary consent, and statutory relief? Is limitation relevant? You finish with remedies. What equitable remedy is available? Can the claimant trace in equity, follow value through substitutions and mixtures, and make a proprietary claim? And through all of it, you keep one consistent theme in mind. Equity regulates conscience, and the solicitor's job is to translate conscience into structured legal analysis with honesty and integrity at every stage. Now you are in a better place to attempt the SQE. Invest in wine if you wish, and you definitely earned a glass for yourself.
Can a crazy man create a valid will? In 1870, the English court answered that very question.
Time to update my will.
Meet John Banks, wealthy, eccentric, and completely convinced he was being haunted by the ghost of a long-dead man named Mr. Featherstone.
I'm not crazy. I am possessed.
Banks believed this ghost was persecuting him, using mesmerism no less to manipulate his thoughts. Now, you might think that someone tormented by spectral mind control wouldn't be trusted to decide who should inherit their estate. But when Banks died and his will was challenged, the court took a different view. Yes, he had a bizarre delusion, but crucially, that delusion had nothing to do with the contents of his will. He understood that he was making a will, he knew what property he had, and he knew who the natural beneficiaries were, in this case his beloved niece. The ghostly obsession didn't influence his choices, and so the court said his will stood. Banks v. Goodfellow became the cornerstone case for testamentary capacity, still good law over 150 years later. So, can a crazy man make a valid will? If he meets the test, absolutely yes. This lecture, prepared by Dr. Yannis, takes you through everything you need to know for FLK Wills and Estates, from validity to probate, tax, and beyond. The aim is to help you revise for this part of the SQE without going crazy.
Validity of wills and codicils. In England and Wales, a will is not merely a personal expression of wishes, it is a legal instrument governed by strict formalities. The validity of a will rests on three central pillars: the mental capacity of the person making the will, the absence of improper pressure or influence, and compliance with formal statutory requirements. Together, these ensure that the testator's instructions are genuine, deliberate, and legally effective. The starting point is testamentary capacity, which is assessed using the well-established criteria from Banks v. Goodfellow 1870. According to this authority, the testator must understand the nature and effect of making a will. They must comprehend the extent of their estate and be able to evaluate the legitimate claims of others, such as family members and dependents. The testator must also be free of mental illness or delusions that could distort their decision-making. It is not enough that a person has been diagnosed with a cognitive condition such as dementia. The court will consider whether the person had a lucid interval, a period of mental clarity at the time of executing the will. A quick note for your exam: you might assume the Mental Capacity Act 2005 applies here. It generally does not for retrospective challenges to a will. The High Court confirmed in Clitheroe v. Bond 2021 that the specific common law test from Banks v. Goodfellow remains the prevailing authority for testamentary capacity, distinct from the general test in the 2005 Act. While newer cases like Baker v. Houston 2023 suggest the Act can be a useful cross-check, Banks remains the primary test you must cite. The second major consideration is the testator's freedom from undue influence. The law protects individuals from being manipulated into making dispositions they do not truly intend. This is particularly relevant in cases involving vulnerable or elderly individuals, where a caregiver, relative, or friend may exploit a position of trust. English law recognizes that persuasion is permissible, but coercion is not. A will procured by undue influence is void. The burden of proving undue influence lies with the person alleging it, and the standard is high. Courts will look for suspicious circumstances, such as the exclusion of close family members without explanation, or a radical departure from a previous will in favor of a recently introduced individual. The third pillar is formality. Section 9 of the Wills Act 1837, as amended, outlines the essential requirements. A valid will must be in writing and signed by the testator or by someone else at their direction and in their presence. The signature must appear intended to give effect to the will. Furthermore, the signature must be made or acknowledged in the presence of two or more witnesses present at the same time. These witnesses must also sign the will in the presence of the testator, although not necessarily in each other's presence. Witnesses should not be beneficiaries or the spouses of beneficiaries, as this will invalidate any gift to them under Section 15 of the same Act. There is no requirement for the will to be dated, although this is strongly advised to avoid disputes about which version of the will is the most recent. All parties must sign with a clear and conscious understanding of what they are doing, and it is best practice to include an attestation clause, a formal statement confirming the observance of the statutory signing requirements. Failure to comply with any of these requirements can invalidate the will, even where the testator's intentions are otherwise clear. This highlights the importance of ensuring all formal steps are followed precisely and underscores the risks of using DIY will kits or informal documents without legal advice.
Personal representatives' appointment, renunciation, and reservation of power. The role of personal representatives is central to the administration of a deceased person's estate. They are responsible for carrying out the terms of the will or for managing the estate under the rules of intestacy if no valid will exists. When appointed under a will, these individuals are called executors. When appointed by the court in the absence of a will, they are known as administrators. Collectively, the term personal representatives applies to both. Under Section 25 of the Administration of Estates Act 1925, personal representatives are charged with a range of legal and practical duties. These include collecting and safeguarding the assets of the estate, paying debts and liabilities, applying for probate or letters of administration, handling inheritance tax, and distributing the net estate to beneficiaries. A will typically names one or more executors. There is no maximum number of executors who may be appointed, but only up to 4 can act at one time due to practical considerations. Executors may be family members, trusted friends, professionals such as solicitors or accountants, or a combination. Where a trust arises, for instance where minor beneficiaries inherit, at least 2 trustees are required. The appointment of executors takes effect from the moment of death. However, they do not have legal authority to deal with the estate until they have obtained a grant of probate. This legal document, issued by the probate registry, confirms their authority and gives them access to the deceased's assets. Nonetheless, some preliminary steps can be taken before probate is granted, such as securing property and arranging the funeral. Sometimes a named executor may not wish or be able to act. They may renounce the role entirely by executing a formal deed of renunciation, provided they have not intermeddled, that is, taken any substantive steps in administering the estate. Once renounced, the role cannot be resumed. This often happens when the named executor is elderly, unwell, or lives abroad and finds the responsibilities too burdensome. Alternatively, an executor may reserve their power. This is more flexible. By doing so, they allow other executors to act while retaining the right to step in later. For example, if there are 3 named executors, one might choose to reserve power and allow the remaining 2 to take out the grant and administer the estate. Reserved power can later be brought into effect if one of the acting executors dies, is removed, or requires assistance. In circumstances where no executor is willing or able to act, a person entitled under the rules of intestacy, usually the residuary beneficiary, may apply for letters of administration with the will. This ensures the estate is still managed even where the will maker's choice of executor cannot be followed through. The flexibility to renounce or reserve ensures that the administration process is not unduly delayed by personal circumstances. However, those taking on the role must appreciate the seriousness of their legal duties. Executors and administrators act in a fiduciary capacity. This means they must act in good faith, avoid conflicts of interest, and not profit from their role unless authorized by the will or the court. Choosing the right executor is a critical part of estate planning. The individual should be trustworthy, reliable, and capable of handling both paperwork and interpersonal dynamics. In complex estates, appointing a solicitor or professional executor may be prudent, especially where there is potential for family conflict, tax issues, or ongoing trusts.
Alterations and amendments to a will. A will is a legal document that reflects a person's intentions at a particular moment in time. However, life changes, relationships evolve, assets are acquired or disposed of, and new family members may arrive. Consequently, it is often necessary to amend or update a will. The law provides mechanisms for doing so, but these must be used correctly to avoid confusion, inconsistency, or invalidity. Alterations to a will can be made in 2 principal ways, either by editing the existing will directly or by executing a codicil. However, the timing and manner in which those changes are made are crucial. If changes are made before the will has been executed, that is, before it has been signed and witnessed in accordance with Section 9 of the Wills Act 1837, they are treated as part of the original will and will be valid if they are clearly incorporated into the document and the final version is executed correctly. For instance, if the testator alters a bequest before signing and the witnesses see and sign that altered version, the change is valid.
On the other hand, alterations made after execution are subject to more stringent scrutiny. To be valid, such changes must themselves comply with the formalities of execution. This means that the alteration must be signed by the testator and witnessed by two witnesses, in the same manner as the will itself. This rarely happens in practice. As a result, many post-execution alterations are found to be invalid and ignored by the probate court. Worse still, unauthorized alterations can cast doubt over the entire document, potentially leading to partial or total intestacy. A safer and more common method of changing a will is through a codicil. A codicil is a supplementary document that amends, revokes, or adds to a previously executed will. It does not replace the original will, but operates in conjunction with it. Codicils are particularly useful for minor changes, such as changing executors, updating a gift, or modifying funeral wishes, without the need to rewrite the entire document. To be valid, a codicil must meet the same formalities as a will. It must be in writing, signed by the testator, and witnessed by two witnesses who are present at the same time. While it is not legally necessary to use the same witnesses as for the original will, doing so can reduce the likelihood of disputes. If a codicil materially alters the distribution of the estate or contains significant changes, best practice is to prepare a new will to avoid confusion or inconsistent provisions. It is possible to have multiple codicils, but each one increases the complexity of interpreting the testator's intentions. If a testator has executed several codicils over time, there is a greater risk of contradiction or ambiguity. Courts must then construe the documents together to give effect to the testator's overall wishes. Another consideration is the physical condition of the will and any codicils. If changes appear to have been made informally, for example handwritten amendments without witnesses or items crossed out, questions may arise about whether the changes were intentional and whether they comply with legal formalities. This can lead to costly litigation or unintended distributions. For this reason, testators are strongly advised never to mark or alter their will themselves without professional legal guidance. In summary, although a will can be amended, doing so must follow prescribed legal routes. Informal edits are unlikely to be valid and may even undermine the clarity or enforceability of the original will. Codicils are an effective and lawful way to make modest changes, but when changes are substantial or numerous, making a new will is almost always preferable.
Revocation of wills. Just as a testator has the legal freedom to make a will, they also have the power to revoke it at any time, provided they retain the mental capacity to do so. The revocation of a will can be a deliberate act, a consequence of changing life circumstances, or the result of certain legal events. Understanding the methods and consequences of revocation is essential for ensuring a person's testamentary wishes are properly respected and updated. There are several ways a will may be revoked: by the execution of a subsequent will or codicil, by physical destruction with the intent to revoke, by written declaration, or by operation of law, particularly following marriage or civil partnership. The most straightforward method is by creating a new will that includes an express revocation clause. Most professionally drafted wills begin with language such as, "I revoke all former wills and testamentary dispositions." This leaves no doubt that the new document is intended to replace earlier ones. Even in the absence of such a clause, a new will that is wholly inconsistent with an earlier one may be treated as an implied revocation. However, this can lead to ambiguity, particularly if the new will omits certain gifts or does not deal with the whole estate. A testator may also revoke a will by physical destruction, as set out in Section 20 of the Wills Act 1837. This includes burning, tearing, or otherwise destroying the will with the intention of revoking it. Crucially, both the act and the intent must be present. Accidental destruction, for example by fire or water damage, does not constitute revocation. Similarly, if another person destroys the will on the testator's instructions, the testator must be present and the destruction must still reflect their deliberate intention. If the only copy of a will was last known to be in the possession of the testator and cannot be found at death, there is a legal presumption that it was intentionally destroyed and revoked. This presumption can be rebutted with sufficient evidence, such as testimony that the will was misplaced or removed by another party without authority.
Nonetheless, the loss of the original will creates significant evidential challenges and may result in partial or total intestacy. It is important to note that partial revocation, removing one part of a will while leaving the rest intact, is not permitted by physical means alone. If a testator attempts to cross out a specific gift without following the proper formalities for alteration, that gift may still stand. To validly revoke a portion of a will, the testator should either execute a codicil or make a new will that replaces the relevant section. These rules illustrate the delicate balance between upholding a testator's autonomy and ensuring clarity and certainty in succession. Legal advice is essential when contemplating revocation, especially if the estate is large, complex, or the testator is vulnerable. Revocation should always be documented in a clear and legally compliant manner to avoid disputes and unintended outcomes.
The interpretation of wills, effect of different types of gift and failure of gifts. The primary goal in interpreting a will is to give effect to the testator's intentions. This principle underpins much of the case law and statutory guidance in this area. However, the words used in a will may not always be clear, and circumstances may have changed between the time the will was made and the time of death. Courts must therefore interpret wills in a way that is legally sound and practically workable, relying on established principles and tools of construction. There are several types of testamentary gifts, and each behaves differently in terms of priority, enforceability, and susceptibility to failure. These include specific gifts, general gifts, demonstrative gifts, and residuary gifts. A specific gift is one that identifies a particular asset, for example, my Rolex watch to my nephew, or the property known as Rose Cottage to my daughter. The hallmark of a specific gift is that it can be precisely identified from the testator's estate. If that item no longer exists at the date of death, the gift is said to have adeemed, that is, it fails entirely and the intended recipient gets nothing in its place. For example, if Rose Cottage was sold before the testator dies, the gift of that property fails, and the beneficiary has no right to the sales proceeds unless the will expressly states otherwise. A general gift is less precise. It refers to an amount or item not tied to a specific asset, such as £5,000 to my cousin. If there are insufficient funds in a particular account, the executors may raise the money from other assets. These gifts are not subject to redemption in the same way as specific gifts. A demonstrative gift straddles both categories. It is a general gift but with a direction to pay it from a specified source. For example, £5,000 from my HSBC savings account to my niece. If that account contains less than £5,000 at death, the balance is paid from other estate assets to make up the shortfall. Demonstrative gifts are not redeemed by the absence or depletion of the named fund. The residuary gift deals with what remains in the estate after all debts, taxes, costs, and other gifts have been paid. It is expressed as the residue of my estate and is often left to one or more main beneficiaries. If a gift fails and the will does not say where it should go instead, it typically falls into the residue. If the residuary gift itself fails, for instance if the named beneficiary predeceases the testator and no substitution is made, then that portion passes according to the intestacy rules. Sometimes a gift fails for reasons other than redemption. The doctrine of lapse provides that a gift to a beneficiary who dies before the testator fails unless a substitution clause or the statutory exception applies. Section 33 of the Wills Act 1837 provides that if a gift is made to a child or remoter descendant of the testator and that person dies before the testator, leaving issue who survived the testator, the gift will not lapse, but instead passes to that issue. This statutory provision can save many gifts that might otherwise fail. Another concept is class gifts, for example to my grandchildren. The law assumes that only grandchildren living at the date of the testator's death are included unless a contrary intention is shown. This becomes particularly important if the testator's family grows after the will is made or if members of the class predecease the testator. Courts interpret class gifts using rules of construction and, where necessary, extrinsic evidence to determine who qualifies. Ambiguities in a will, for example where the wording is unclear or inconsistent, can be addressed using the principles of construction. Courts aim to interpret the will as a whole and resolve ambiguities in a way that makes practical and legal sense. If ambiguity remains, extrinsic evidence may be admitted under Section 21 of the Administration of Justice Act 1982, including statements made by the testator about their intentions.
Courts may also rectify a will under Section 20 of the same Act, where the will fails to carry out the testator's intentions due to clerical error or a failure by the drafter to understand instructions. The applicant must provide strong evidence, and the claim must be brought within 6 months of the grant of representation, although the court may allow later applications in exceptional cases. The law of interpretation also includes the armchair principle, where the court puts itself in the testator's position at the time the will was made, considering their knowledge, circumstances, and relationships. This helps clarify unclear provisions and is especially useful where family structures are complex or where names are used inconsistently. In short, interpreting a will is not simply a matter of reading its words. It requires a holistic approach that respects the testator's intentions, adheres to legal principles, and addresses any practical or evidential difficulties. A properly drafted and regularly updated will can greatly reduce the risk of misinterpretation or the failure of gifts.
The Intestacy Rules, Section 46 of the Administration of Estates Act 1925, and the Statutory Trusts. When a person dies without leaving a valid will, or when part of their estate is not effectively disposed of by a will, their estate, or the undisposed portion, is distributed according to the statutory rules of intestacy. These rules are set out in Section 46 of the Administration of Estates Act 1925, as amended, and they provide a strict order of priority among surviving family members. Importantly, the rules apply regardless of the deceased's actual wishes or the closeness of their emotional relationships. The structure of intestate succession aims to reflect a presumed order of entitlement, with priority generally given to spouses, civil partners, and blood relatives. Cohabiting partners who were not married or in a civil partnership with the deceased have no automatic right under the intestacy rules, even if they lived together for many years. If the deceased leaves a surviving spouse or civil partner but no children, the entire estate passes to that surviving partner. However, if there are children or other descendants, the estate is divided. The surviving spouse or civil partner receives all the deceased's personal chattels, defined broadly as personal possessions not used for business purposes or held as investments, a statutory legacy, currently set at £322,000 as of 2023, free of inheritance tax and interest bearing from the date of death until payment, 1/2 of the remainder of the estate, after the above two items are satisfied, absolutely. The other half of the remaining estate is divided equally between the surviving children of the deceased. Where a child has died before the deceased but left children of their own, i.e. the deceased's grandchildren, those grandchildren will inherit that child's share per stirpes by representation of their parents' entitlement. In the absence of a surviving spouse or civil partner, the whole estate passes to the other relatives in a strict order of priority. 1. Parents. 2. Whole blood siblings or their children. 3. Half-blood siblings or their children. 4. Grandparents. 5. Uncles and aunts of the whole blood or their children. 6. Uncles and aunts of the half-blood or their children. If no such relatives can be found, the estate becomes bona vacantia. It passes to the Crown. In practice, the Treasury Solicitor's bona vacantia division manages such estates, and it may distribute some funds to those who can show a moral, though not legal, claim. Under intestacy, the property passing to children or remoter descendants is held on a statutory trust until they reach the age of 18. During this period, the trustees, often the administrators of the estate, hold the assets for the benefit of the minor beneficiary. They have the power to advance capital or pay income for the minor's maintenance, education, or benefit. This statutory trust protects the minor from mismanaging an inheritance and ensures oversight until they reach legal adulthood. However, it also means that the assets cannot be freely accessed or controlled by the child or their guardians until the legal age is reached, unless the trustees exercise discretion to make advances earlier. The same structure applies to more remote beneficiaries, for example nieces or nephews inheriting under the intestacy rules in the absence of closer relatives. Each class of beneficiary receives their share subject to the trust, which continues until the legal age is attained.
It is important to note that the statutory rules make no allowance for individual circumstances, such as financial dependence, estrangement, or the testator's actual preferences. Consequently, they can produce outcomes that seem unfair or contrary to what the deceased might have intended. This rigidity underscores the importance of making a valid will to avoid unwanted distributions and to provide for non-entitled individuals, such as unmarried partners, stepchildren, or friends. While claims under the Inheritance Provision for Family and Dependents Act 1975 can sometimes rectify the harshness of intestacy, these claims are not automatic and they require time, evidence, and legal expense. The best way to avoid such disputes is for individuals to take control of their estate planning by executing a legally valid and regularly reviewed will.
Property passing outside the estate, joint property, life policies, pension scheme benefits, and trust property. Not all of a deceased person's wealth forms part of their estate for the purposes of inheritance, probate, or taxation. Some types of property pass outside the estate automatically by operation of law or contract. It is essential for both practitioners and personal representatives to recognize these types of property as they affect who inherits, whether a grant of probate is needed, and how inheritance tax is calculated. Joint property. The most common form of property that passes outside the estate is jointly owned property held as joint tenants. Under this arrangement, two or more people hold the property with no distinct shares. Instead, each owns the whole together. Upon the death of one joint tenant, the property passes automatically to the surviving joint tenants by the right of survivorship, regardless of what is stated in the deceased's will or the intestacy rules. This principle applies most commonly to joint bank accounts, savings, and homes owned in joint names. The legal mechanism is automatic and does not require probate. However, it does not apply to property held as tenants in common, where each party owns a defined share. In such cases, the deceased's share passes under their will or the intestacy rules. It is important for testators to understand the nature of their co-ownership. For example, a person may assume that they can leave their share of the family home to someone else by will, only to find that their joint tenancy means it automatically passes to their co-owner. Severance of the joint tenancy, converting it into a tenancy in common, is therefore an important step where a different succession plan is intended. For inheritance tax purposes, jointly owned assets are still relevant. Half the value of jointly owned property may be included in the deceased's estate, depending on how the asset was structured and who provided the funds. This affects tax liability even if the asset does not pass under the will. Life policies. Life insurance policies can either form part of the estate or pass outside it, depending on how they're structured. If the policy is written in trust, which is a common estate planning tool, the proceeds are paid directly to the named trustees for the benefit of designated beneficiaries. In such cases, the funds bypass the estate entirely, do not require probate, and are not subject to the deceased's debts or will. This provides a powerful tool for testators who wish to make immediate provision for dependents or reduce the inheritance tax burden on their estate. Trust-based life policies can be set up during lifetime, often with the assistance of financial advisors, and offer flexibility in how proceeds are applied. If the policy is not in trust, the proceeds usually fall into the estate and are distributed under the terms of the will or intestacy. These proceeds are also potentially liable for inheritance tax, increasing the estate's tax burden.
Pension scheme benefits. Pension death benefits are another significant form of wealth that may pass outside the estate. Many pension schemes, particularly occupational and personal pensions, include a discretionary death-in-service benefit or a lump sum payable upon death. These are usually governed by the scheme's rules and do not automatically form part of the estate. Instead, the pension scheme trustees have discretion over who receives the benefit. Most schemes allow the member to nominate preferred beneficiaries, but these nominations are not binding. Nonetheless, trustees usually follow them unless there is a good reason not to. Because the benefit does not form part of the estate, it is not governed by the will or intestacy rules, nor is it typically subject to inheritance tax. This makes pensions a tax-efficient way to pass on wealth. However, it also means that care must be taken to keep beneficiary nominations up to date. A failure to do so can result in delays or unintended recipients. It is also worth noting that pension pots held in drawdown or as uncrystallised funds can be left to beneficiaries, and if the deceased was under 75 at death, these may be inherited tax-free. Trust property. If the deceased was a trustee of a trust, the assets of that trust are not part of their estate. The legal title to the trust property vests in the continuing or replacement trustees. However, steps must be taken to vest that title formally in the remaining trustees, typically through a deed or formal resolution. If the deceased had a beneficial interest in a trust, for example a life interest or a share in capital, then that interest may pass under their will or intestacy, and it may form part of their taxable estate. But the trust assets themselves remain separate and are not part of the estate for succession purposes. Trusts are often used in estate planning to ring-fence assets, protect beneficiaries, and reduce tax exposure. Common examples include discretionary trusts, life interest trusts, and pilot trusts. Each operates according to its own terms, which may dictate what happens to the assets upon the death of the beneficiary or settler. It is vital for personal representatives to identify whether the deceased had any involvement with trusts, either as a trustee or beneficiary. Trust documentation, solicitor correspondence, and tax records can help determine this. Ignoring trust property can lead to breaches of duty or tax miscalculations.
Grants of representation. A grant of representation is the legal document that authorizes an individual to deal with the estate of a deceased person. Without it, financial institutions, government departments, and others will typically refuse to release the deceased's assets. Whether the deceased died testate with a valid will or intestate without a valid will, some form of grant is usually required to administer their estate. The need for a grant arises when the estate contains assets that cannot be accessed without legal authority. This typically includes real property, bank accounts above a certain threshold, shares, and investments. If the estate is small, usually below £5,000 to £15,000, depending on the institution, a grant may not be required. Likewise, assets that pass outside the estate, such as joint property or nominated pensions, do not require a grant to be transferred. When a valid will exists and appoints executors who are willing and able to act, they apply for a grant of probate. If no will is available, or if the executors are unable or unwilling to act, then a grant of letters of administration is issued instead. Where there is a will but no executor willing to act, the court may issue a grant of letters of administration with will. The non-contentious probate rules and application procedure. The process for obtaining a grant is governed by the Non-Contentious Probate Rules 1987. These rules set out the procedural steps, documents required, and forms to be used in applications for probate or administration. Applications can be made by post, online, or through a solicitor. In more complex cases, such as where there is uncertainty about the will or disputes between beneficiaries, the application may need to be handled in the probate registry or, occasionally, in the family division of the High Court. The key steps in the application process include assembling the necessary documents, including the original will, death certificate, and completed inheritance tax forms, valuing the estate, identifying all assets and liabilities, including property, bank accounts, debts, and other interests, submitting an inheritance tax return, either a short form IHT 205 for accepted estates or a full IHT 400 for taxable or complex estates, swearing an oath or making a legal statement confirming the truth of the application, paying any inheritance tax due, at least in part, before the grant is issued. Once the application is approved and all documents are in order, the grant is issued to the personal representatives. This gives them the legal authority to collect and deal with the deceased's assets. Valuation of assets and liabilities. Accurate valuation is essential for probate and tax purposes. Assets must be valued as at the date of death. This includes real property, based on open market value, bank balances, investments, personal possessions, and business interests. Liabilities, such as mortgages, loans, unpaid taxes, and outstanding bills, must also be recorded. Over- or undervaluation can affect the tax payable and expose the personal representatives to legal liability. For property, a professional valuation or agent estimation is used. Shares must be valued using stock exchange prices on the date of death. For unusual assets, such as antiques, intellectual property, or cryptocurrency, specialist advice may be needed. Accepted estates.
An estate may be classified as an accepted estate if it meets certain criteria, such as having a value below the inheritance tax threshold, being left entirely to an exempt beneficiary, e.g. spouse or charity, or if the deceased was domiciled abroad with limited UK assets. In such cases, a simplified inheritance tax return, IHT 205, can be used, and there is no need to submit a full account to HMRC. This streamlined process speeds up the grant application and reduces administrative burden. However, the rules for accepted estates are strict, and any error can result in delays or penalties. It is therefore important to check eligibility carefully. Methods of funding inheritance tax. Inheritance tax, IHT, must be paid, at least in part, before the grant is issued. This presents a practical difficulty. The funds to pay the tax may be locked in the deceased's assets, which cannot be accessed without the grant. To address this, HMRC allows the tax due on certain assets, particularly land and shares, to be paid by instalments over 10 years. Interest is charged, but this allows flexibility in managing cash flow. Additionally, many banks will release funds directly to HMRC to settle the IHT liability, provided the appropriate forms are completed. Alternatively, personal representatives may use their own funds, take out loans, or sell certain assets early with caution to fund the tax payment. Specialist probate lending services also exist to assist with this issue. Burden and incidence of inheritance tax. The burden of inheritance tax refers to who ultimately pays the tax. Generally, it falls on the estate, that is, it is paid before any distributions are made to beneficiaries. However, the incidence of tax, which assets are used to fund the payment, is governed by the will or the rules of intestacy. If the will is silent, the general rule is that specific and demonstrative legacies are paid in full, and the residuary estate bears the tax. If a gift is made free of tax, the tax is paid from the estate. If it is not, the beneficiary bears the tax. These distinctions can have significant implications for beneficiaries, especially if gifts are large or if there are multiple classes of legacy. Executors must ensure that tax is correctly apportioned and paid in accordance with both legal principles and the wording of the will. Errors can result in personal liability, disputes between beneficiaries, or HMRC investigations.
Administration of estates, duties, liabilities, and distribution. Once the grant of representation is obtained, the personal representatives, whether executors or administrators, are empowered to administer the estate. This is a detailed and often time-consuming process that must be carried out with diligence, impartiality, and adherence to legal standards. The personal representatives act in a fiduciary capacity, meaning they must act in the best interests of the estate and its beneficiaries, and can be held personally liable for breaches of duty. Duties of personal representatives. The duties of personal representatives can be broadly categorized into 4 key phases: collect, administer, account, and distribute. 1. Collect. The representatives must identify, locate, and gather all the deceased's assets. This includes closing bank accounts, selling property, redeeming investments, and recovering debts owed to the estate. They must also secure physical assets, such as properties or valuable items, to prevent loss or damage. 2. Administer. The estate's liabilities must be settled. This includes paying funeral expenses, outstanding bills, taxes, including inheritance tax, income tax, and capital gains tax, and debts. If the estate is insolvent or marginal, careful management and possibly professional advice are needed to avoid distributing assets prematurely. 3. Account. Representatives must maintain detailed financial records throughout the process. This includes preparing estate accounts showing assets received, expenses paid, and the calculation of net distributions. Beneficiaries have the right to see relevant information and, in some cases, a full account of the administration. 4. Distribute. After all liabilities and expenses are paid, the remaining assets can be distributed in accordance with the will or intestacy rules. This may involve transferring property, paying legacies, or setting up trusts. Distributions must reflect the terms of the will and the correct shares under the law. Liabilities of personal representatives and their protection. The role of personal representative carries significant legal responsibility. If they make errors, for example by failing to pay debts before distributing assets or by misinterpreting the will, they can be held personally liable to creditors or disgruntled beneficiaries. To mitigate this risk, personal representatives can protect themselves in several ways. Statutory notices.
Under Section 27 of the Trustee Act 1925, representatives can place notices in the London Gazette and a local newspaper, giving creditors 2 months to come forward. If no claims are made within that time, the representatives may distribute the estate without being personally liable for unknown debts. Professional advice. Where the estate is complex, contentious, or involves tax planning, representatives should seek advice from solicitors, tax specialists, or accountants. Acting on competent professional advice can be a defense to certain claims. Indemnities. In some cases, representatives may require beneficiaries to sign indemnities before distribution, particularly where issues of uncertainty remain. Insurance. Executors' insurance is available and can provide cover for legal costs and claims arising from mistakes in administration. Failure to act properly can lead to removal by the court, compensation claims, or proceedings under the Inheritance Provision for Family and Dependents Act 1975.
Sale of assets to pay expenses, tax, debts, and legacies. Where the estate lacks liquid funds, personal representatives may need to sell assets to meet obligations. This can include selling shares, real property, or valuable items. The power to do so arises either from the will itself or from statute, particularly under the Administration of Estates Act 1925 and the Trustee Act 1925. Care must be taken to ensure fair value is obtained for assets, especially if beneficiaries challenge the sale. If land or a family home must be sold, this may require sensitive handling and clear communication with beneficiaries, particularly where the property is occupied. Representatives must also determine the correct order of payment. 1. Funeral expenses. 2. Testamentary expenses, for example, probate fees or professional fees. 3. Secured debts. 4. Unsecured debts. 5. Legacies, in the order specific, demonstrative, and general. 6. Residuary bequests. If the estate is insolvent, the rules of bankruptcy apply to the order of distribution, and professional advice is essential to avoid missteps. Distribution of the estate. After all liabilities are paid, the estate is ready for distribution. The representatives must ensure that each beneficiary receives their correct entitlement. This may be a fixed sum, a pecuniary legacy, a specific item, a specific legacy, or a share of the residue. Before distributing, the representatives should verify the identity and legal capacity of each beneficiary. In the case of minors or vulnerable beneficiaries, funds may be held on trust or paid to a parent or guardian, depending on the circumstances and the terms of the will or statutory trust. Where the will establishes ongoing trusts, such as for a life interest or discretionary trust, the administration does not end with distribution. The ongoing role of trustees must be established and assets properly transferred into trust with supporting documentation. Upon completion of the administration, personal representatives often provide a final estate account to the beneficiaries, setting out receipts, payments, and distributions. This serves as a record of their administration and may help preempt disputes or challenges.
Claims against estates under the Inheritance for Family and Dependents Act 1975. Although English law respects the principle of testamentary freedom, the right of individuals to dispose of their estate as they wish, that freedom is not absolute. In some circumstances, the law allows disappointed or excluded individuals to claim that the deceased's will, or the effect of the intestacy rules, fails to make reasonable financial provision for them. These claims are made under the Inheritance for Family and Dependents Act 1975. This legislation provides an important safety net, particularly for those who were financially dependent on the deceased or had a strong personal connection but no entitlement under the will or intestacy. It balances personal freedom with social responsibility. Time limit. An application under the 1975 Act must normally be brought within 6 months of the date on which the grant of representation is issued. This is a strict time limit. However, the court has discretion to allow late applications in exceptional circumstances, especially where the delay was short and there is a strong case on the merits. Applicants must show that it is just and equitable to extend time. Late applications are more likely to succeed where the estate has not yet been distributed or where the claimant was unaware of their entitlement or the existence of the grant. However, the longer the delay, the harder it becomes to justify an extension. Eligible applicants. Only certain categories of individuals have the right to apply under the Act. These are 1. The spouse or civil partner of the deceased, entitled to a higher standard of provision, similar to what they might expect in a divorce proceedings under the Matrimonial Causes Act 1973. This includes factors such as the length of the marriage, the standard of living enjoyed, and the applicant's financial needs. For all other applicants, including adult children and cohabitants, the standard is lower. They must show that their maintenance is reasonable rather than that they are entitled to share in the estate more broadly. Factors considered by the court include the applicant's current and future financial needs and resources, the financial needs and resources of other beneficiaries, the size and nature of the estate, the obligations and responsibilities the deceased had towards the applicant and others, any physical or mental disability of the applicant, any other relevant circumstance, including the conduct of the parties. For example, a financially dependent adult child with a disability may be awarded provision, whereas a financially secure adult child estranged from the deceased may not. The court retains broad discretion. In Illott v. the Blue Cross and others 2017, the Supreme Court upheld a modest award to an estranged adult daughter who had been excluded from her mother's will in favor of charities. The case reaffirmed the testator's freedom to choose beneficiaries, but confirmed that maintenance-based claims could succeed in limited circumstances. If successful, the court may vary the distribution of the estate to make appropriate provision. This can include lump sums, property transfers, or ongoing maintenance payments. Awards may be made from specific assets or from the estate as a whole, depending on what is just and practical. These claims can have a significant impact on beneficiaries and may result in delays, costs, or changes in distribution. Executors must take care not to distribute the estate prematurely if a claim is pending or likely. If a claim is made, the estate administration may be paused while the parties negotiate or the court makes a determination. Personal representatives who distribute the estate in ignorance of a pending claim may be liable if the court later finds that provision should have been made. Therefore, it is often advisable for representatives to delay final distributions until the claim period has passed or a deed of variation or settlement is agreed.
Taxation, wills and the administration of estates. The taxation of estates involves three main areas: inheritance tax, IHT, income tax, and capital gains tax, CGT. Understanding these obligations is essential for personal representatives and beneficiaries alike, as tax liabilities can significantly affect the value of the estate and the timing of distributions. Inheritance tax, lifetime transfers and transfers on death. Inheritance tax is primarily governed by the Inheritance Tax Act 1984. It is charged on the value of a person's estate at death, as well on certain gifts made during their lifetime. The standard nil rate band is £325,000 as of 2023, and any part of the estate above this threshold is taxed at 40% unless exemptions or reliefs apply. Lifetime transfers fall into two categories: immediately chargeable transfers and potentially exempt transfers, PETs. Immediately chargeable transfers typically involve gifts into most trusts, excluding certain bare trusts or disabled persons trusts. These are subject to IHT at 20% lifetime rate if they exceed the nil rate band. If the donor dies within 7 years of the transfer, a further 20% may be payable to bring the total up to 40%. Potentially exempt transfers are outright gifts made to individuals. They are only taxable if the donor dies within 7 years. If death occurs within this period, the gift is added back into the estate for IHT purposes. Taper relief may reduce the tax payable if the gift was made more than 3 years before death. The longer the interval, the greater the relief. Importantly, if the donor retained a benefit from the gift, for example by continuing to live in a property they had given away, the gift is treated as a gift with reservation of benefit. In such cases, it remains part of the estate for tax purposes under anti-avoidance rules. On death, the value of the estate is assessed, including lifetime gifts made within 7 years. Personal representatives must report these gifts using the IHT 400 form if the estate is not an accepted estate.
The timing of gifts and the availability of reliefs, such as taper relief or business relief, must be carefully considered. Exemptions and reliefs. Several important exemptions and reliefs can reduce the IHT liability. Spouse or civil partner exemption. Gifts to a UK-domiciled spouse or civil partner, whether made during life or on death, are entirely exempt from IHT. Charity exemption. Gifts to UK-registered charities are also exempt. Annual exemption. Individuals may give away up to £3,000 per tax year free of IHT. If unused, it can be carried forward 1 year. Small gift exemption. Gifts of up to £250 per person per year to any number of individuals are exempt. Wedding gifts. Gifts made on the occasion of a marriage or civil partnership are exempt up to £5,000 from a parent, £2,500 from a grandparent, or £1,000 from others. Business relief. Up to 100% relief is available for certain business assets held for at least 2 years. Agricultural relief. Similar relief applies to qualifying agricultural property. The residence nil rate band is an additional allowance where a residence is left to a direct descendant. The allowance is currently £175,000 and tapers away for estates exceeding £2 million. Unused portions of both the standard and residence nil rate bands can be transferred between spouses or civil partners on death. Anti-avoidance provisions. The tax regime includes various anti-avoidance measures to prevent individuals from artificially reducing their estates for tax purposes. Gifts with reservation of benefit, as noted, gifts where the donor continues to benefit from the asset are not effective for tax mitigation and are taxed as part of the estate. Pre-owned asset tax, PAOT, introduced to catch arrangements that fall outside the reservation of benefit rules. POAT imposes an annual income tax charge where a donor continues to enjoy the benefit of an asset they previously owned. Settlements and trusts. Transfers into discretionary or interest in possession trusts may attract lifetime or periodic charges unless structured correctly. Personal representatives must be alert to these provisions when reviewing the deceased's finances and planning any distributions.
Income and capital gains tax in respect of the period of the administration of an estate. In addition to inheritance tax, the administration of an estate may give rise to further tax liabilities, namely income tax and capital gains tax, CGT. These taxes apply to the estate as it generates income or realizes gains between the date of death and the final distribution to beneficiaries. The personal representatives, PRs, are responsible for managing and paying these taxes during the administration period. The personal representative's liability to income tax and capital gains tax. The estate becomes a taxable entity upon death. During the period of administration, it may continue to earn income from interest on savings, dividends from shares, rental income from properties or other sources. This income must be declared to HMRNC, and the estate is taxed at the applicable rates. Personal representatives are treated as a single taxable person and are responsible for filing tax returns if the estate earns significant income or realizes taxable gains. Smaller estates may benefit from the informal payment procedures, whereby PRs can settle tax without filing full returns, provided the tax liability is minor. For larger or more complex estates, formal self-assessment tax returns are required. For income tax purposes, interest is taxed at 20%, dividends are taxed at 8.75%, rental income and other trading income are taxed at the basic rate of 20%. PRs are not entitled to the personal allowance, unlike individual taxpayers, but they may deduct allowable expenses related to estate management, such as agents' fees, insurance, or repairs on a lead property in calculating taxable income. For capital gains tax purposes, PRs may realize gains if they sell estate assets that have increased in value since the date of death. For example, if shares appreciated between death and their sale, the gain is taxable. Similarly, if a property increases in value before being sold, CGT may apply. PRs benefit from a reduced annual CGT exemption during the administration period. As of 2023-24, the allowance is £6,000 per tax year, compared to £12,300 for individuals, reducing further to £3,000 from April 2024.
Any gains above this amount are taxed at 10% for most assets, 18% for residential property, basic rate, 20% and 28% respectively for higher rate gains depending on the asset. Losses on asset sales may be used to offset gains within the same year or carried forward to future years of administration. The administration period is generally treated as ending when all assets are distributed or vested in a continuing trust. CGT planning is important. If the estate holds appreciating assets, PRs may consider appropriating assets to beneficiaries before sale, allowing those beneficiaries to use their own CGT allowances and potentially lower rates. Beneficiaries' liability to CGT on inherited assets. When beneficiaries inherit assets from the estate, they receive them at their market value as at the date of death, known as the probate value or base cost for tax purposes. This is a key distinction from gifts during life, which transfer the donor's original acquisition cost. If a beneficiary later disposes of an inherited asset, such as selling inherited shares, property, or a valuable item, they may realize a capital gain. The gain is calculated as the difference between the probate value and the sale price. The beneficiary is liable for CGT on this amount, subject to their annual allowance and applicable rates. For example, if an individual inherits a property worth £300,000 at the date of death and later sells it for £350,000, the £50,000 gain may be subject to CGT. If the property was the beneficiary's main residence, principal private residence relief may apply. Otherwise, standard CGT rules determine the liability. Beneficiaries are not liable for CGT or income tax at the point of inheritance itself, only if and when they dispose of the asset. They should therefore keep accurate records of the probate value and any costs incurred in maintaining or selling the asset, as these may affect their tax position. Income received by a beneficiary from the estate, for example, income from an interest in possession trust or from income-producing assets during the administration period, is also potentially taxable. PRs must provide the beneficiaries with the appropriate tax certificates, Form R185, to allow them to declare and, if applicable, claim tax credits or refunds. In estates with ongoing trusts, tax liabilities may continue well beyond the administration period. Trustees then become responsible for tax compliance and reporting, and beneficiaries may need to complete annual tax returns depending on the trust income they receive.
Conclusion. So can a crazy man make a valid will? As we saw at the start, yes, if he meets the test. Banks v. Goodfellow reminds us that testamentary capacity isn't about being eccentric or even delusional. It's about understanding what a will does, what property you own, and who has a claim on your estate. That principle still underpins everything we've explored. Over the course of this guide, we've covered the full landscape of wills and estates for FLK2. You've seen what makes a will valid, testamentary capacity, freedom from undue influence, and strict formalities. We explored how wills can be altered, revoked, or interpreted, and what happens when they fail or gifts lapse. We looked at what happens when there is no will, and how the intestacy rules distribute estates according to strict legal priorities, not emotional ones. We've examined the role and duties of personal representatives, how they're appointed, what powers they hold, and how they manage debts, taxes, and distributions. We've broken down the mechanics of probate, the purpose of grants of representation, and what property passes outside the estate, from joint assets to pensions and trusts. We've looked at claims under the Inheritance for Provision for Family and Dependents Act 1975, who can bring them, what they must prove, and how the court balances fairness with freedom. And finally, we've unpacked the complex but vital world of taxation, from inheritance tax to income and capital gains tax during the administration period. Together, these topics make up the wills and estates component of FLK2, a subject that's as much about people as it is about law. Because when someone dies, what they leave behind and how it's handled can be one of the most meaningful legal moments in a person's life and legacy.
What do you know about leases in English law?
Picture this. You are advising a property investor who wants to rent out rooms but insists on avoiding giving occupiers any statutory protection. To outsmart the system, they draft a document called a license. It says the owner can enter the room whenever they wish and can share the space if needed. In practice, though, the occupier is given the keys, moves in, pays weekly, locks the door, and is treated as the only person entitled to that room. A year later, the investor wants them out and gives them 24 hours notice. The occupier refuses. The investor storms into your office, waving the document and pointing to the word license in bold at the top. They want immediate eviction. This is the moment your client learns that property law is not fooled by labels. A court looks at the substance of the arrangement, not the language chosen by the parties. If the occupier has exclusive possession for a certain term, the arrangement may be a lease, whatever the document says. That is the lesson of Street v. Mountford, and it remains one of the central ideas you need for the SQE.
Welcome back to the channel. Dr. Yannis has prepared our session for today. We are going to work through leases across the SQE syllabus. Leases matter because they sit at the meeting point of land law and property practice. In land law, a lease is a proprietary estate in land. In practice, it becomes a transaction, a set of covenants, a possession issue, a tax issue, and sometimes an insolvency issue too. For SQE purposes, you need to understand the whole life cycle: how a lease is created, how to distinguish it from a license, how leasehold covenants operate, how leases end, and how the rules differ between commercial premises, residential premises in England, and residential property in Wales.
The Land Law Foundation. What makes a lease? The first question is always whether the arrangement is really a lease or only a license. The classic authority is Street v. Mountford. The key indicators are exclusive possession, a certain term, and usually rent, although rent is not essential. The real focus is exclusive possession. If the occupier has the right to exclude the world at large, including the landlord, except to the extent of any genuine right of entry, that strongly points towards a lease. If the landlord genuinely retains control, genuinely shares occupation, or provides attendance or services inconsistent with exclusive possession, the arrangement may be a license. This is where sham clauses matter. A landlord cannot avoid a lease simply by drafting clever wording. If a supposed right to share occupation or enter freely is not genuine, the court may ignore it. For the SQE, always ask what is happening in reality. Who has control of the premises? Can the occupier exclude others? Is the arrangement for a certain term? If the answer points towards exclusive possession for a term, you should be thinking lease, not license. Once you identify a lease in substance, the next question is whether it is legal or equitable. That distinction matters because it affects enforceability, registration, and priority. A legal lease will usually need to be created by deed.
There is, however, an important exception for a short lease. A lease can still be legal without a deed if it takes effect in possession, is for a term not exceeding 3 years, and is granted at the best rent reasonably obtainable without a fine or premium. That is a classic SQE formalities point, and an easy place to drop marks if you state the rule too loosely. In registered land, a lease granted for more than 7 years must also be registered to operate as a legal estate. So a lease may exist in substance, but fail to take effect as a legal lease if the formalities are wrong. If the parties intended to create a longer lease but failed to use a deed, equity may still recognise the arrangement if there is a specifically enforceable contract satisfying Section 2 of the Law of Property Miscellaneous Provisions Act 1989. That gives you an equitable lease rather than a legal one. For the SQE, the practical habit is simple. Identify the lease, then immediately ask whether the interest is legal or equitable, because that changes the analysis on title, priority, and remedies.
Leasehold covenants and the parties bound. Once the lease exists, you move from creation to operation. A lease is full of covenants. The tenant may promise to pay rent, repair, insure, or avoid alterations. The landlord may promise quiet enjoyment, non-derogation from grant, or to provide services in a larger building. At the start of the lease, the original landlord and the original tenant are bound because they are in privity of contract. The lease may later be assigned, and this is where students often mix up the rules. The assignee becomes the new tenant, and the reversion may also be transferred to a new landlord. At that stage, the running of covenants depends on the distinction between older and newer leases. For leases granted before 1st January 1996, the old law can leave the original tenant contractually liable even after assignment. That means a landlord may, in some circumstances, pursue the original tenant years later for breaches committed by later assignees. For leases granted on or after 1st January 1996, the Landlord and Tenant Covenants Act 1995 changed the position. The outgoing tenant is generally released from future liability on assignment, but the landlord may require an authorised guarantee agreement, or AGA, under which the outgoing tenant guarantees the obligations of the immediate assignee. The important limitation is that the AGA is generally only a one-link guarantee. It does not usually make the outgoing tenant liable forever for everyone further down the line. For the SQE, the key habit is to check the date of the lease. If it is pre-1996, think old continuing liability rules. If it is post-1995, think statutory release plus possible AGA.
How leases come to an end. A lease can end in several ways. The simplest is effluxion of time, where the fixed term expires. A periodic tenancy may end by proper notice to quit. A lease may also end by surrender, where the tenant gives up the term and the landlord accepts it. Or by merger, where the leasehold and reversion come into the same ownership in the same right. An express surrender usually requires a deed, but surrender may also occur by operation of law, inferred from conduct that is clearly inconsistent with the continuation of the lease. For example, if the tenant gives up possession and the landlord unequivocally accepts that the tenancy is over, the law may treat that as surrender even without a formal deed. The most heavily tested termination mechanism is forfeiture. Forfeiture allows the landlord to bring the lease to an end because the tenant has breached a covenant. Because it is a harsh remedy, the law controls it carefully. For most breaches other than non-payment of rent, the landlord will usually need to serve a Section 146 notice under the Law of Property Act 1925. That notice must specify the breach, require it to be remedied if it is capable of remedy, and require compensation where appropriate. Only after that can the landlord move towards forfeiture, and even then the tenant may seek relief from forfeiture.
For non-payment of rent, a Section 146 notice is generally not required before forfeiture steps are taken. But do not oversimplify the remedy. The tenant may still apply for relief, and the court may restore the lease if the arrears and costs are dealt with. Also, be very careful about the property type. In some commercial contexts, peaceable re-entry may be possible if the lease reserves the right. In residential premises let as a dwelling, a landlord cannot simply force entry and throw the occupier out. Residential possession is tightly regulated, and unlawful eviction rules must be respected. That is a practical point the SQE may test indirectly through a client scenario.
Commercial leases. Commercial leases are central to property practice. They combine drafting, negotiation, statutory protection, title investigation, and remedies. The major statutory feature is security of tenure under Part 2 of the Landlord and Tenant Act 1954. If the tenancy is a qualifying business tenancy and has not been validly excluded from the Act, the tenant does not simply lose the premises when the contractual term expires. Instead, the tenancy continues on statutory terms until terminated in accordance with the Act, and the tenant may have the right to a new tenancy. If the landlord wants possession back, they must follow the statutory procedure and rely on one of the grounds in Section 30. Some grounds are based on tenant default, such as persistent delay in paying rent or other substantial breaches. Others are not fault-based, such as the landlord's intention to redevelop. Ground F, redevelopment, is a classic exam issue. The landlord must show a genuine and settled intention to carry out the works, and that they could not reasonably do so without possession.
In some cases, where the landlord opposes renewal on a no-fault ground, the tenant may be entitled to statutory compensation. Commercial leases are also about covenants. Repair, insurance, user, rent review, and alienation are often the commercial battleground. In a so-called FRI lease, the tenant usually bears the financial burden of repair and insurance, either directly or through service charge and reimbursement mechanisms. A tenant taking an older building must read the repair covenant with great care, because a full repairing obligation may in some cases require the tenant to put the premises into repair, not merely preserve them in their existing state. That is why tenants often negotiate a schedule of condition to limit liability by reference to the property's state at the outset. Alienation clauses regulate assignment, underletting, sharing occupation, and parting with possession. The lease may prohibit alienation absolutely, allow it freely, or allow it only with landlord's consent. Where the covenant is qualified and consent is needed, the law may control the landlord's refusal. In the relevant circumstances, Section 19 of the Landlord and Tenant Act 1927 prevents the landlord from withholding consent unreasonably, and the Landlord and Tenant Act 1988 imposes duties to deal with a written application for consent within a reasonable time, and to give written reasons where consent is refused. In practice, the landlord may seek an AGA as the price of consenting to assignment.
Residential tenancies in England. The position now. This is the area where you need to be especially careful, because older textbooks and older SQE materials may already be out of date. Historically, the standard private rented model in England was the Assured Shorthold Tenancy, or AST, and landlords often relied on Section 21 as a no-fault route to possession. But the law has changed. From 1 May 2026, the Renters' Rights Act 2025 abolishes assured shorthold tenancies in the private rented sector in England and ends Section 21 no-fault evictions. Most existing ASTs convert into assured periodic tenancies, and new private rented tenancies are now created within that reformed assured tenancy structure, rather than as ASTs with an end date. For SQE purposes, that means two things. First, always check the timing of the question. If you are looking at an older problem or legacy material, it may still use AST language and discuss Section 21. Second, for the current law in England, the landlord's focus is now on the available statutory grounds for possession, not on a general no-fault route under Section 21. That is the safe, modern framework to teach and revise. Older AST compliance rules still matter in transitional contexts and in understanding how the system used to operate. Under that earlier framework, deposit protection, prescribed information, gas safety requirements, the energy performance certificate, and the how to rent material could affect whether Section 21 was available. But for a current 2026 teaching script, those points should be framed as part of the old or transitional landscape, not as the main statement of present law. If the landlord seeks possession because of tenant fault, such as arrears or other breaches, the analysis continues to revolve around the relevant statutory grounds and the correct possession procedure. So the modern SQE habit for England is this: identify the tenancy type under the current regime, identify the relevant statutory ground if possession is sought, and check procedural compliance carefully.
Wales. You must also stay alert to jurisdiction. Wales has taken a different path. The Old English Tenancy and Licence framework does not apply in the same way to most residential lettings in Wales because the Renting Homes Wales Act 2016 replaced it with occupation contracts. In the private rented sector, the default arrangement is generally a standard occupation contract. That means different terminology, different documentation, and different possession rules. One of the major practical points is the written statement. For new occupation contracts, the landlord must provide the written statement within 14 days of the occupation date. Failure to comply can create serious practical and legal difficulties and may expose the landlord to consequences under the Welsh regime. For the SQE, the habit is simple.
If the property is in Cardiff, Swansea, or anywhere else in Wales, do not instinctively apply English tenancy language. Spot Wales first, then move into the occupation contract framework.
Tax points on leases. Tax runs across leasehold transactions and practice. For VAT, the starting point is often that supplies of land are exempt, but commercial property owners may opt to tax, allowing them to recover input VAT on expenditure and leading to VAT being charged on rent and other relevant supplies. That matters in practice because the economic cost of a lease may be higher than the headline rent suggests. For transaction taxes, leases can trigger tax not only on any premium, but also on the rent payable over the term. In England, that means SDLT, in Wales, LTT. The rent element is calculated using a net present value approach. For students, the point is not to memorise every number, but to remember that leases are taxed differently from simple freehold transfers, and that both premium and rent may be relevant. Lease length may also matter for capital gains treatment. Short leases can raise issues because they are not economically the same as permanent interests. On the SQE, the safe approach is not to get lost in tax detail, but to spot that lease structure, rent, premium, VAT status, and jurisdiction can all affect the transaction. Insolvency crossover. Leases frequently appear in insolvency problems. If a company tenant goes into liquidation, the liquidator may disclaim onerous property, including a lease. That allows the company to shed the future burden of the tenancy, though it does not erase every consequence for other interested parties. The landlord may be left with a claim in the insolvency rather than a continuing tenant paying rent. Administration is different. Because administration is designed around rescue, survival, or a better realisation for creditors, a statutory moratorium restricts landlord action. A landlord may be unable to forfeit, sue, or take other enforcement steps without consent or the permission of the court, depending on the stage and facts. On the SQE, the vital skill is not to panic when insolvency appears. Just ask, what kind of insolvency is this, and what does it do to the landlord's remedies? Every stage of lease law is really about risk allocation. The lease tells you who controls the premises, who pays, who repairs, who can assign, and how the relationship ends. For the SQE, you need to be able to move confidently between land law and practical problem solving. So remember the core traps. Do not trust labels when distinguishing a lease from a license. Check whether the lease is legal or equitable. Remember the short lease exception properly. Possession, no more than 3 years, best rent, and no premium. Check the date of the lease when dealing with covenant liability in the 1995 Act. Be careful with forfeiture and never treat residential eviction as if a landlord can simply re-enter. In commercial leases, think 1954 Act security of tenure, repair, insurance, and alienation. In residential work, check the jurisdiction first, and remember that in England from 1 May 2026, Section 21 and the AST model no longer define the mainstream private rented sector. In Wales, think occupation contracts, not ASTs. Master those distinctions, and you will not just know what a lease is, you will know how to analyse it, from creation to termination, from title to possession, and from transaction to dispute. And that is exactly the level of understanding the SQE is looking for.
Congratulations on buying your first house. Or, well, thinking you have.
What are you doing here? Who are you?
You found the property, agreed the price,
What are you doing in my house?
instructed solicitors, and transferred £470,000 for completion.
Your house? You better call your solicitors, boy.
Contracts are exchanged, the money goes through, the deal is done. Except there is just one small problem. The person who sold you the house doesn't actually own it.
This really happened in England in the case Paransing v. A Court and Co. A fraudster impersonated the owner of a house in Wimbledon, convinced solicitors he was the seller, and the buyer transferred the entire purchase price before anyone realized the truth. By the time the fraud was discovered, the money had been transferred overseas and disappeared. The buyer had paid nearly £500,000, and legally, he didn't own the house. Cases like this remind us that conveyancing is not just paperwork. Every search, every title investigation, every identity check exists to prevent exactly this kind of disaster. In this video, Dr. Yannis is going to walk you through property law and practice for SQE FLK 2, following the SRA syllabus and explaining the real work a solicitor does in property transactions, from investigating title and raising inquiries all the way to exchange of contracts, completion, commercial leases, and property taxes.
Introduction to the Professional Standard. When we begin studying property practice for the SQE, it is useful to imagine the everyday work of a solicitor in a conveyancing transaction. The SRA assessment specification requires candidates to demonstrate the ability to act honestly and with integrity, applying the law at the level of a competent, newly qualified solicitor. This is a high bar. It requires more than the memorization of statutes. It requires a deep understanding of the procedural architecture that underpins the transfer of land in England and Wales. A client walks into the office and says they want to buy a property. From this initial instruction, the solicitor's primary function is risk management. At that moment, the solicitor's role becomes one of investigation. The solicitor must ensure that the seller actually owns the property and that the buyer will receive good title once the transaction completes. If a solicitor fails in this duty, if they miss a restrictive covenant that prevents the client's intended use, or if they fail to secure a valid mortgage charge for the lender, they expose themselves to negligence claims and their client to financial ruin. Therefore, we must approach this topic with rigorous attention to detail. Section 1. Freehold Real Estate. The investigation of title. In England and Wales, land ownership is largely governed by the system of title registration administered by HM Land Registry. The Land Registration Act 2002 is the governing statute, aiming to create a mirror of the title, where the register accurately reflects the state of ownership. Most land is now registered, meaning that ownership is recorded on a central register. However, a competent solicitor must recognize that the mirror is not always perfect. There are cracks in the mirror, interests that bind the land despite not appearing on the register, known as overriding interests. Furthermore, some land remains unregistered, particularly property that has been in the same family ownership for decades. A solicitor must therefore be able to investigate both registered and unregistered titles with equal facility.
The registered title investigation. In a registered title investigation, the starting point is the official copies entries obtained from the land registry. These entries replace the historic title deeds and are treated as definitive evidence of ownership. When you download these from the Land Registry portal, you are looking at the state of the title at that precise timestamp. The official copies consist of 3 parts, each serving a distinct legal function. First is the property register. The property register describes the property and identifies the land included in the title. It usually refers to a title plan. As a solicitor, you must verify that the address matches the client's expectations. Crucially, this register also states the estate held. Is it freehold or leasehold? It may also list the benefits of any easements, such as a right-of-way over a neighbour's driveway to access a garage. If the property benefits from such a right, you must check that the benefit is expressed clearly and acts in perpetuity. Second is the proprietorship register. The proprietorship register identifies the owner and may also contain restrictions affecting how the property can be transferred. You must check the class of title. Ideally, this will be title absolute, the highest class of guarantee.
However, you may encounter possessory title, often granted where deeds were lost or title is based on adverse possession. This is risky and may require indemnity insurance. You may also see qualified title, where a specific defect exists. This register also lists restrictions in the standard Form A, Form P, or similar. A Form A restriction, for example, indicates a trust of land, requiring purchase money to be paid to at least 2 trustees to overreach any beneficial interests. If you miss this, your client takes the land subject to the rights of beneficiaries, a catastrophic error. Third is the charges register. The charges register lists financial charges, such as mortgages, and may also include restrictive covenants, easements, or other encumbrances affecting the property. This is the burden section of the title. The solicitor analysing these entries must check that the seller is the registered proprietor and that the title being transferred corresponds with the property being sold. If a mortgage is registered, the solicitor must ensure it will be discharged on completion. This is typically done by obtaining an undertaking from the seller's solicitor. You will also see restrictive covenants here, promises not to do something, like not to use the premises for the sale of alcohol. If there are restrictive covenants or easements, the buyer must be informed, because these obligations may affect how the property can be used.
The unregistered title investigation. Unregistered land requires a different approach. Because ownership is not recorded centrally, title must be deduced through a chain of title deeds, usually covering at least 15 years. This 15-year period is statutory, set by the Law of Property Act 1969. The seller must produce an epitome of title, a schedule of documents. This collection of documents is known as an epitome of title. The critical first step is identifying the root of title. A good root of title must meet 4 criteria. It must be at least 15 years old, it must deal with the whole legal and equitable interest, it must cast no doubt on the validity of the title, and it must contain an adequate description of the property. The most common route is a conveyance on sale. The solicitor reviews the deeds to confirm that ownership has passed lawfully from one owner to another until it reaches the current seller. You are checking the chain of ownership. If a link in the chain is missing, for example, if a previous owner died and there is no grant of probate attached to the deed proving the transfer to the executor, the title is defective. Each transfer must be properly executed and any mortgages or charges must be discharged. Furthermore, in unregistered land, third-party rights are not on a central register attached to the property. Instead, they are registered against a name of the landowner at the Central Land Charges Department in Plymouth. You must perform a K-15 land charges search against every owner named in the chain of title for the period of their ownership. This search reveals Class C-IV estate contracts, Class D-2 restrictive covenants, and Class F matrimonial home rights. The purpose of this investigation is to ensure that the seller has good title and that the buyer will acquire ownership free from undisclosed risks. If problems arise, the solicitor must decide what further action is required. For example, there may be missing documents, unresolved charges, or rights affecting the property. If a deed is lost, can secondary evidence be provided? If a restrictive covenant is breached, can we obtain a retrospective consent or insurance? The solicitor might require additional evidence, obtain indemnity insurance, or raise further inquiries with the seller's solicitor. Once the investigation is complete, the solicitor prepares a report on title for the client. This document explains the legal status of the property, identifies any risks, and confirms whether the buyer can safely proceed with the purchase. Reporting to the client is a crucial professional duty, because it ensures that the client understands both the benefits and the risks of the transaction.
Section 2. Pre-contract searches and inquiries. Investigating the legal title is only part of the solicitor's role. Title deeds do not tell you if a motorway is planned next door or if the land is contaminated. The buyer must also discover whether there are external factors affecting the property that may not appear on the title itself. This is the purpose of searches and inquiries. Searches are formal requests for information from public authorities or other organizations. The suite of searches you order depends on the location and nature of the property, but 3 are considered mandatory in almost all purchases: the local authority search, the water and drainage search, and the environmental search. One of the most important is the local authority search. This is actually two searches, the LLC-1, Local Land Charges Register, and the CON-29, Enquiries of the Local Authority. The LLC-1 reveals legally binding charges like tree preservation orders, conservation area designations, or financial charges for street works. The CON-29 reveals planning history, building regulations, and highway status. This reveals matters such as planning permissions, building regulation approvals, compulsory purchase proposals, or enforcement notices affecting the property. A property may look attractive to a buyer, but if the local authority has served an enforcement notice requiring alterations or demolition, that fact could fundamentally affect the decision to proceed. For example, if a previous owner built an extension without building regulations approval, the local authority could prosecute or demand rectification. Environmental searches are also common. These searches reveal whether the property may be contaminated land, located in a flood risk zone, or affected by historic industrial activity. Under the Environmental Protection Act 1990, local authorities can designate land as contaminated. The remediation costs fall on the Class A person, the polluter. If they cannot be found, liability passes to the Class B person, the current owner. In modern conveyancing practice, these searches are essential because environmental liability can sometimes pass to the current owner of land. If the search result is failed, further investigation is needed. Water and drainage searches confirm whether the property is connected to mains water and sewer systems and whether any public drains run beneath the land. This is conducted via the CON-29DW form. This matters because building over a sewer may require special permission and can create legal complications. If a public sewer runs under the garden, the water company has statutory rights of access. Depending on location, you may also need a mining search, Coal Authority CON-29M, or a chancel repair search. Chancel repair liability is an ancient right, allowing the church to demand funds for repairs from local landowners. While its status as an overriding interest changed in 2013, it can still bind purchasers in specific circumstances if a notice has been entered on the title.
Alongside searches, the buyer's solicitor raises inquiries with the seller's solicitor. For residential property, this is done via the TA6 Property Information Form. These inquiries request additional information about the property, such as disputes with neighbours, alterations carried out to the property, or guarantees relating to building works. The principle of caveat emptor, buyer beware, applies to the physical state of the property, but the seller must answer inquiries truthfully. A false answer can lead to a claim for misrepresentation. The seller responds through standard forms and additional correspondence. The solicitor must then review the results of both searches and inquiries. If issues arise, further investigation may be required. For example, if the local search reveals that a road serving the property is not publicly adopted, the buyer must consider whether maintenance obligations will fall on the property owner. Modern conveyancing practice is guided by the Law Society Conveyancing Protocol, which sets out best practice standards for residential transactions. The protocol encourages cooperation between solicitors, transparency in communication, and efficient progression of the transaction. While it does not replace legal rules, it reflects professional expectations of good conveyancing practice.
Section 3. Finance and the role of the lender. Most property transactions involve some form of finance. For many buyers, purchasing property without borrowing would be impossible. A solicitor therefore needs to understand the main sources of finance used in property transactions. The most common form of finance is a mortgage loan from a bank or building society. In a mortgage transaction, the lender provides funds to the buyer and receives security over the property. This security allows the lender to take possession of the property and sell it if the borrower fails to repay the loan. This right of possession arises immediately upon the creation of the mortgage term, though in practice it is only exercised upon default. There are different types of mortgage products. A repayment mortgage involves the borrower making regular payments that gradually repay both the capital and interest. An interest-only mortgage requires the borrower to pay only interest during the term, with the capital repaid at the end. From a solicitor's perspective, the key issue is not the financial structure of the loan, but the legal security created over the property. The lender's security usually takes the form of a legal charge registered against the title. Once registered, this charge gives the lender priority over later interests and protects its right to recover the loan. In many transactions, the buyer solicitor also acts for the lender. This dual representation is permitted provided there is no conflict of interest. This is a specific exception to the general SRA rules on conflict, justified by the standard nature of mortgages. However, if a conflict arises, for example, if the buyer asks you not to tell the lender about a cashback incentive from the seller, you must cease acting. When acting for the lender, the solicitor must follow the lender's specific instructions, often set out in the UK Finance Mortgage Lender's Handbook. One of the most important responsibilities is providing the certificate of title. This is usually part of the Report on Title form. This document confirms to the lender that the property offers good security for the loan. By issuing the certificate of title, the solicitor effectively assures the lender that the property has good title, that all necessary searches have been carried out, and that the lender's charge will be properly registered. Because the lender relies heavily on the solicitor's certification, accuracy and professional diligence are essential. Any negligence in investigating title could expose the solicitor to liability if the lender suffers loss.
Section 4. Exchange of contracts. Once title investigations, searches, and finance arrangements are complete, the transaction moves towards exchange of contracts. This is the watershed moment. Before exchange, either party can walk away without penalty. After exchange, the deal is binding. At this stage, the parties negotiate and agree the terms of the sale contract. Most residential transactions incorporate the Standard Conditions of Sale, SCS, published by the Law Society. Currently, the SCS 5th edition is standard. Commercial transactions often rely on the Standard Commercial Property Conditions, SCPC. These standard conditions provide a consistent framework for issues such as completion dates, deposit arrangements, and remedies for breach. However, the parties may also include special conditions in the contract. Special conditions address matters specific to the transaction, such as completion deadlines linked to a related purchase or obligations to remedy defects in the property before completion. A common special condition involves vacant possession, ensuring the seller removes all chattels and rubbish. One important practical issue concerns the deposit. Usually the buyer pays a deposit of 10% of the purchase price on exchange of contracts. The deposit may be held by the seller's solicitor either as stakeholder or as agent. Under the standard conditions, it is typically held as stakeholder. If held as stakeholder, the solicitor holds the money independently until completion. This protects the buyer. If the seller goes bust before completion, the money is safe. If held as agent, the solicitor holds it on behalf of the seller and it may be released immediately. This is rare in residential cases but common in new-build developer sales where the developer uses the cash to fund construction. Insurance and risk are also addressed in the contract. Under traditional rules and Standard Condition 5.1, risk passes to the buyer upon exchange of contracts, meaning the buyer should insure the property from that moment. If the house burns down between exchange and completion, the buyer must still complete the purchase. In practice, many buyers arrange insurance immediately after exchange to protect against damage before completion. Another matter that sometimes arises is VAT. Residential property is usually exempt. However, certain commercial property transactions may attract value-added tax if the seller has opted to tax the property. The contract must therefore specify whether VAT is payable in addition to the purchase price. The exchange of contracts itself is usually carried out by telephone between the solicitors. The Law Society provides formulas for exchange. Formula A is where one solicitor holds both signed parts. Formula B is where each holds their client's signed part, most common. Formula C is for chains. Once contracts are exchanged, the agreement becomes legally binding. The buyer is obliged to purchase the property and the seller is obliged to transfer it on the agreed completion date. If either party withdraws after exchange, they risk significant financial consequences, including loss of deposit and damages.
Section 5. Pre-completion and completion. Between exchange of contracts and completion, there is a period during which final preparations are made. This stage is known as pre-completion. One key task is preparing the transfer deed, usually in the form known as TR1 for registered land. The transfer deed formally transfers ownership of the property from the seller to the buyer. While the contract is the promise to sell, the TR1 is the document that actually moves the legal estate. It must be properly executed as a deed, meaning it must be signed and witnessed according to legal formalities. The buyer's solicitor also conducts pre-completion searches. One of these is the OS1 priority search at the Land Registry, which protects the buyer's priority during the registration process. This search freezes the register for 30 working days. If a hostile creditor tries to register a charging order during this window, the buyer takes priority. Another is a bankruptcy search, Case 16, against the buyer if the purchase is financed by a mortgage, ensuring that the buyer is not bankrupt before the lender releases funds. At the same time, the solicitor arranges for mortgage funds to be drawn down from the lender. The solicitor sends a certificate on title or report on title to the bank, requesting the cash for the completion day. The completion statement is prepared, showing the balance required from the buyer after taking account of the deposit and mortgage advance. Completion is the moment when ownership of the property legally passes from seller to buyer. This occurs when the purchase money is transferred to the seller's solicitor and the seller's solicitor releases the executed transfer deed. In modern conveyancing practice, completion usually takes place electronically through the banking system via CHAPS. Once funds are received, the seller's solicitor confirms completion and authorizes the buyer to take possession of the property. The keys are released, usually via the estate agent. After completion, the solicitor must carry out several post-completion tasks. These are strictly time-critical. First, paying any stamp duty land tax due and submitting the necessary return to HM Revenue and Customs. This must be done within 14 days of completion. Failure incurs automatic penalties. Second, the solicitor must apply to the Land Registry to register the buyer as the new owner and register any mortgage charge. Registration is crucial because in registered land systems, the register determines legal ownership. Until registration occurs, the buyer holds only an equitable interest. If the application is not made within the OS1 priority period, the buyer risks third-party interests taking precedence. Occasionally, a party fails to complete the transaction on the agreed date. When this happens, the law provides several remedies. Time is not automatically of the essence in property contracts unless stated. Therefore, a notice to complete can be served by the innocent party. This notice makes time of the essence and gives the defaulting party a short period, usually 10 working days, to complete the transaction. If completion still does not occur, the innocent party may rescind the contract. Rescission brings the contract to an end and allows the innocent party to recover the deposit if the seller's at fault or forfeit the deposit if the buyer's at fault. Damages may also be claimed to compensate for losses caused by the delay.
Section 6. Leasehold Real Estate Law and Practice. We now turn to the more complex area of leasehold law. Unlike freehold, where you own the land forever, leasehold property involves the grant of exclusive possession for a defined period of time in exchange for rent. This creates an ongoing relationship. The lease sets out the contractual relationship between landlord and tenant. Commercial leases typically contain a series of covenants governing the use and management of the property. A competent solicitor must understand the holy trinity of lease covenants: repair, user, and alienation. Repair obligations determine which party is responsible for maintaining the premises. In a full repairing and insuring (FRI) lease, the tenant is liable for all repairs. A trap for the unwary is the obligation to keep in repair, which implies an obligation to put the property into repair as if it is dilapidated at the start. Insurance clauses allocate responsibility for insuring the building and paying the insurance rent. Usually the landlord insures and the tenant pays the insurance rent. Alteration clauses regulate whether the tenant may modify the property. Some leases prohibit structural alterations without landlord consent, while allowing minor internal changes. User clauses restrict the permitted use of the premises. For example, a lease might allow use as retail premises but prohibit residential use. This is distinct from planning permission. A use might be legal under planning law but banned by the lease. Commercial leasing practice is influenced by the Code for Leasing Business Premises, which promotes fairness and transparency in commercial leasing negotiations.
Procedures: grant and assignment. The grant of a commercial lease follows a process similar to that used in property sales. The parties negotiate the terms and may first enter into an agreement for lease. This preliminary contract obliges the parties to grant the lease once certain conditions are met, such as the landlord completing construction of the unit. Before the lease is granted, the tenant's solicitor investigates the landlord's title to ensure the landlord has the legal right to grant the lease. Assignment occurs when an existing tenant transfers the lease to a new tenant. The new tenant becomes responsible for the obligations under the lease. The incoming tenant's solicitor investigates the lease terms and the landlord's title. Landlord consent may be required if the lease contains restrictions on assignment. Where landlord consent is required, it is documented through a license to assign or license to underlet. This document records the landlord's consent and sets out conditions attached to the transaction. It establishes a direct contractual link or privity of contract between the landlord and the incoming assignee. Sometimes the landlord requires an authorized guarantee agreement, often called an AGA. This agreement obliges the outgoing tenant to guarantee the performance of the new tenant's obligations under the lease. This is a crucial concept deriving from the Landlord and Tenant Act 1995. Liability and remedies. The liability of tenants and landlords under lease covenants depends partly on the date the lease was granted. For old leases granted before 1 January 1996, the doctrine of privity of contract meant that original tenants could remain liable for lease obligations even after assigning the lease for the entire 99 years, regardless of who was in occupation. For new leases granted on or after that date, the Landlord and Tenant Covenants 1995 changed the position. Under this legislation, liability generally passes to the assignee when the lease is transferred, though the AGA mechanism allows the landlord to hook the immediate predecessor back in if the new tenant defaults. If a tenant breaches a lease covenant, the landlord has several possible remedies. One option is an action in debt to recover unpaid rent. Another is forfeiture, which allows the landlord to terminate the lease if the tenant seriously breaches its obligations. Forfeiture is a draconian remedy and usually requires a peaceable re-entry or changing the locks or court proceedings. However, the landlord must be careful not to waive the right to forfeit by accepting rent after knowing of the breach. Commercial Rent Arrears Recovery, or CARR, allows landlords to seize goods belonging to the tenant to recover unpaid rent. This replaces the old law of distress. Some leases include a Jervis v. Harris clause, allowing landlords to enter the property and carry out repairs themselves if the tenant fails to do so, recovering the cost as a debt. Termination and security of tenure. A lease may end by affliction of time, surrender, or merger. However, commercial tenants may benefit from statutory protection under the Landlord and Tenant Act 1954. This legislation grants business tenants security of tenure, meaning they have the right to request a new lease when the existing lease expires. The lease doesn't just end, it holds over until a statutory notice is served. To terminate a protected tenancy, a landlord must serve a Section 25 notice stating a ground of opposition. The landlord may oppose renewal on certain statutory grounds, such as redevelopment plans, ground F, or persistent breaches of the lease, grounds A, B, C. If renewal is granted, the court may determine the terms of the new lease, including rent levels, usually based on open market rent. In some cases, tenants may also receive compensation if the landlord successfully opposes renewal, particularly under no-fault grounds like redevelopment.
Section 7. Planning, Law and Taxation. Finally, we touch upon the regulatory and fiscal framework. Planning law regulates how land may be developed and used. The statutory definition of development generally includes building operations and material changes in the use of land. Not all development requires planning permission. Some activities fall within permitted development rights, such as small home extensions. However, if you breach planning control, the local authority can issue an enforcement notice. It is vital to note that under the Levelling Up and Regeneration Act 2023, the time limits for enforcement have been unified to 10 years for all breaches in England, effectively abolishing the old 4-year rule. On the fiscal side, property transactions are subject to taxation. Stamp duty land tax (SDLT) in England and land transaction tax (LTT) in Wales are charged on the consideration. These taxes are calculated using a slice system, where different rates apply to different portions of the price. Residential purchases often involve progressive tax bands, and surcharges apply for second homes, an extra 3%, or non-resident buyers, an extra 2%.
Value-added tax, VAT, may apply to commercial property. Most commercial property transactions are exempt from VAT, but if the seller has exercised an option to tax, VAT at 20% is added to the price. Sometimes clients choose to opt to tax in order to recover VAT incurred on property development. Lastly, capital gains tax, CGT, arises when a person disposes of an asset and realizes a gain. For individuals, this is charged at rates of 18 or 24% for residential property. However, private residence relief allows individuals to avoid capital gains tax on the sale of their main residence. The unfortunate story we started with captures the entire point of property law and practice in the SQE. Every step we studied, from the SRA specification, investigating title, analyzing land registry entries, carrying out searches, raising inquiries, dealing with lenders, exchanging contracts, completing the transfer, registering the title, understanding leases, planning controls, and property taxes, exists to make sure that when someone buys land, the law recognizes that they truly own it. I hope this video helped make the system behind property transactions clearer for your FLK2 preparation. Thank you for watching, and good luck with your SQE preparation.